decided they're under the extent of conflict does exist, given the waivers, the court will. All right. Are we ready on anything you have? No. Bye. Okay.
I want to check in with Mr.
Out there. There's someone in tow.
Good morning, Your Honor.
Good morning. Hey, we need lunch. But we don't know what we're having because we have to wait on someone. Take care, Mr. Simon. Always a pleasure, sir. Where is everybody?
Wilmington Billions. This topic.
Well,
If we can,
well, Mr. Cook's here. Ms. Faltes left. Joy's here. Who's in the hallway? Are they ready? I don't want that one. Court does call the case, People State of Michigan versus Ronald Bay.
and you're honoring the cook for the people.
Good morning, Your Honor. Joy Haynes, Senior Assistant Public Defender, with on behalf of Mr. Bay. Would you please?
Good morning, Your Honor. Ronald Bay. Good morning. I like that. He did. All right, go ahead. I'm sorry.
Some people are unable to proceed.
Your Honor, we move for a dismissal.
People being unable to proceed, this case is dismissed on the motion of the defendant. All right. Thank you, sir. Have a great day.
Thank you.
To say. Nice jacket.
Hope you can hear it.
What did you say? It's not really my color. All right. Okay, Ann, I'll stop talking. I'll sit here and look stoic. It can only last for a few minutes. Oh, no.
See? Here, can we get them?
Yeah, you're on you were saying. Oh, I want it. What do you need?
Is never here. Standing. Yeah.
I did.
Oh.
Court does call the case of the People State of Michigan versus Marquise Johnson.
Morning, Your Honor, Raymond Cook for the people.
Well, on behalf of Marquise Johnson, standing in for Attorney of Record Bill Amadeo with Mr. Johnson's permission. Is that correct, Mr. Johnson?
Yes.
And please state your name for the record.
Marquise Johnson. Thank you.
Your Honor, it's the date and time set for preliminary examination. At this time, the people are unable to proceed.
That's moves for dismissal.
For being unable to proceed, this case is dismissed on the defendant's motion. That is without it.
Mr. Johnson has some hardware from the county. He's on a tether. Can he go over today and get that removed?
From the county. Like he won a trophy or something. Where do you? He wants to go get rid of it?
Yes, Judge.
Why he doesn't like it?
I mean, it doesn't really go with his outfit.
No, you just said outright no. I can. I should make him keep it then. He can go over it. They should take it off. If there's a problem, tell them to call our chambers. And that way they'll know that it's dismissed. But come on.
Thank you, Judge.
All right. Thank you, sir. Okay, that's 3. Yay, Alex here. Gonna get better. Or it could turn and go south. Good, good. Yeah. Don't think. Who would read it? Yeah. It's vague. Okay, I heard it. And like, what is it?
My concern is just including from jail. I haven't made experience in my mouth. All right.
Hey, how are you?
See, my pleasure.
What are we doing?
Ready.
Yes, it does. Court does call the case, People versus Derek Hurd Jr.
Then on behalf of Your Honor,
This court televised on behalf of Mr. Stern. Yes, to my immediate right.
Right, your name?
Oh, Derek Hurd.
Thank you, sir.
and your today's date times up for preliminary examination. At this time, if people are unable to proceed as to counts 1 and 2, and would ask for counts 3 and 4 to be remanded down to district court.
All right, you're moving to dismiss counts 1 and 2.
I have no objection, Your Honor. But could we expedite this movement to a district court resolution? My client is on parole, and the only thing holding him is these counts.
I can give him it's before me, so I can give him the soonest date I can possibly give it.
Thank you, Your Honor. Appreciate that.
Counts 1 and 2 are dismissed. Counts, it's 4 count. I'll continue to defendants not guilty plea to counts 3 and 4. I'll set pretrial in this matter for
May 4th at 1 p.m.
Your Honor, the May 4th is the one day I cannot do.
so I pick the one day. You asked me to hurry it up, and I pick a date, and then you tell me I can't do it. Really, Lions, come on.
Stuff like a lawyer.
What?
But I've got an armed robbery exam that day with
Yes.
5 co-defendants.
When is my next? It's got it. I can do the following week, the 11th.
May 11th, I will make that work.
All right.
A question, are we going to do that live or by the magic?
It'll be live because
Not a problem. And that's,
so that'll be pretrial May 11th, 2026, 1 p.m.,
Cool.
12 noon.
thank you, Your Honor.
All right. Before me. Thank you. Bond will continue. Thank you. Susan. Susan, sir. Just. Oh. Getting,
She's going.
say again.
Voting rights.
Walk that point.
Who did? Where is she? No, I'd tackle her. All right, don't do that. You're okay, because see, when I walked in, you were the only one from that side in here.
She was.
I know. We marked that down. What's Hall doing?
Well, it's a long list, Judge.
Oh. I don't know what they're talking about. He doesn't care. Court doesn't really want to talk to me. Court calls the case, Peter versus Michael McClure.
I'm bringing the people.
And good morning, Your Honor. Joseph Payne on behalf of Mr. McClure, who is approaching. Mr. McClure, if you could state your name for the record. Thomas McClure.
Anytime set for preliminary examination, assuming people are unable to proceed.
Defense would move to dismiss, Your Honor.
People being unable to proceed. This case is dismissed on defendant's motion. Thank you.
Thank you very much, Your Honor.
Work briefly on.
Yes.
What's that? Was it on that? It is. Yes, yes.
Flew it all the way from London. I wanted to come.
Oh, did he? Oh, okay. I can talk British. I can. Let's focus.
Let's get awesome first. Your job.
Oh, cheerio. It is.
Make sure that's.
Oh, so you're not ready.
No, you don't. Paperwork.
The charge. If you plead guilty or if you're found guilty, you could be incarcerated 1 day for every $10 owed. So you could receive 25 days jail. You can satisfy that in part by payment, in part by serving a jail term, or in full by paying the amount due. You can purge the entire contempt. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? You have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that? Would you like an attorney? To the charge you failed to pay $249, how do you plead? You failed to pay?
I won't be able to pay.
No, I said, did you fail to pay? Did you fail to pay the amount due on this? Anybody force you to plead guilty?
No.
Why don't you come in and pay it?
I can't get it.
Why didn't you come in and pay it?
I deal with CPS.
You work?
Lost my job after that. Yeah,
You'll be working.
I was working for Amazon.
How much do you have today?
How much like a minute?
How much do you have today?
We have like a couple bucks.
$2?
I have like 4, maybe 5. I won't be able to pay until the 26th of May. I'll be able to pay the full amount.
Are you sure?
Yes.
Next time you gotta come and talk to us when you don't have the money, okay?
Okay,
So I'll give you until the 28th to pay, okay?
okay.
If you, May 28th, if you don't have the money, you can either come in here on or before the due date at 8:30. Or you can, call the court on or before that due date at 8:30 in the morning, and I'll give you an extension. Just don't ignore us, okay?
I'll,
All right. Anything else? All right, good luck. You're welcome. People against, Cottrell. Cameron Jamal Cottrell. 25W839925. Your name?
County Trail.
See, now this kind of thing I don't understand. What did I just tell him? What did I just tell him? Did you hear?
Yeah, about, calling, we need to make an extension or something.
I told you that too.
Yeah,
Hang on. When I gave you a payment plan on January 23rd, and you told me you could pay $50 per week beginning February 9th. You haven't paid a nickel since then, and you didn't extend the courtesy of coming in here and talking to me or calling the court and saying, can I get on Zoom with the judge? I need it. Did you? Why not?
I've been taking care of my father in Atlanta, so I got,
I'm sorry?
I've been taking care of my father in Atlanta, so I
You
completely.
been in Atlanta for 3 months?
Huh?
You been in Atlanta for 2.5 months?
Yes, sir.
Did you,
I just completely forgot. It just.
you forgot? You know what the title of my book's gonna be? Don't tell the judge I forgot. You didn't forget it. You just kind of blew it off. And you probably haven't been in Atlanta for 2.5 months, right? You want to go get your itinerary and show me when you flew there and when you flew back?
No, I drove, man.
You drove there and you were there for 2.5 months.
Sir.
When did you come back?
A couple of days ago, my mail goes to my grandfather's house. My aunt told me that I had a court date.
Remember when I told you you could Zoom? You could have Zoomed from Atlanta, couldn't you?
I didn't know I could.
I told you that. I tell everyone. If you want, I'll go listen to the recording right now. I know I told you that because I tell everybody that. And you didn't do that because you don't have any respect.
No, I do something.
Well, you don't respect the judiciary. If you had respect, listen, I don't know how many judges offer that. I'd be surprised if there's more than 3 in the state that do that. Maybe they have, maybe they all do it. I don't know. But when I tell you that you have to at least give us the courtesy of calling up and going on Zoom and requesting an extension, and you don't do it, and you blow it off for 3 months, it doesn't make me happy.
Understand?
Do you?
Yes, sir.
Where you work?
For
Ford Motor?
the text somewhere
Where?
on 4 Greenfield.
You didn't take off 2.5 months working at Ford. They'd have fired you
No, I just started Monday.
Monday.
This past Monday.
Yesterday?
Yes, sir.
You started yesterday.
Yes, through a temp service.
You don't believe it. Okay? I don't believe you were in Atlanta for 2.5 months.
They're helping my father.
Just so you know, I don't believe you. Okay? I have people lie to me every day. All right?
Mhm.
I don't know what it is. Maybe I don't look very smart. But I get tired of it.
I understand.
Do you?
Sir.
This is a courtroom. We're not in a bar. We're not telling fish stories. You pull this nonsense with me again, you're going to force me to put you in jail on a civil infraction, and I won't hesitate. Do we understand one another?
Yes, sir.
When can you start paying?
I have the full payment next number. That's correct.
Are you sure?
Yes, sir.
I can give you more time if you want.
No, that's fine.
What are you going to do if you don't have the money?
I'll have money. Okay.
No. Let's say something happens. Your engine goes out on your car. The bank forecloses. You got a credit card. What are you going to do if you don't have the money?
Reach out to family and friends.
No, you're going to call the court, or you're going to drive to the court on or before the due date at 8:30 in the morning. I'll give you an extension.
Okay.
I mean, I can't be more fair than that, can I?
Correct.
You pay by me. Week from Friday is the 8th. I'm giving you till the 13th. Again, I want to treat you like a child. What are you going to do if you don't have them? On or before the due date, right?
Right.
That's if you can operate the unit. If you can't, you have to come in here on or before the due date, okay? All right, May 13th. Good luck. Timothy Jamie Whittle. 25B148379B, 21F235726A, 25B148379C, and 25B148379A. Your name?
Timothy General.
All right, so Mr. Whittle, I set a sentence date. This was first of all, let's talk about let's talk about the possession of a controlled substance. But I want you to understand before we go further that you have the right to an attorney. If you, either way, I will be glad to appoint you on a public expense. Do you understand?
Yes.
Would you like an attorney?
No.
Are you sure?
Yes.
You had one before, didn't you?
Yes.
I think you need one. Now, here's the problem. Our probation court-appointed lawyer got detained in Florida, I believe. His flight didn't go out, so we had to call somebody. So I'm going to give you your choice. You can either wait for him to get here, and I don't have any idea how long it will take, or I'll reschedule this for a week or two. And that'll give you more time to come up with money and do whatever else. So I'm going to give you your choice. What would you like to do?
Reschedule.
I'd get going on this if I was you. Heather, when are we going to reschedule this probation? I can go a week, I can go 2 weeks, whatever you want.
We have probation docket next on May 11th.
Okay, so we'll make
We should do probably 11:15.
at 11:15 in the morning, May 11th, 11:15 in the morning. Okay?
Yes.
I don't think you're taking care of this very well. I don't want to talk about it. And I expect you, sir, to take care of your business. Did you hear what I said? Maybe you did. But something said defendant behind on payment plan, reschedule with probation violation hearing. That's what they said on April 14th. So unless you came in and paid and the staff made a mistake by not putting it on there,
I don't know.
I don't want you to talk until we get a lawyer for you, okay? So you're going to have to figure things out. How old are you again?
24. Sorry, 25. Sorry.
Well, happy birthday. $511 at 11:15, they'll give you your notice down the hall, okay? It's time to grow up. Okay? Time to grow up. Good luck. You too. Go down the hall and get your notice. What do you guys have in here? What's your name?
Michael DeBeau. I'm Stephen Chartrand.
Do you have him on the docket? What do you have, Mr.
DeBeau, speeding ticket.
Did you meet with the department rep?
No, I'm supposed to,
Let me see that. What's he?
Spell it.
DEPUGH.
Yeah, at 9:30.
Oh, it's at 9:30. Is it a department rep?
Yes.
Sure, how about you?
I have the same thing. It's for a speeding ticket at 9:30, through Woodhaven.
I see it.
Have John take them over there when he gets back. Yeah, I understand. So you should be in conference room 3. Sadie, would you take them to that conference room and tell the department rep that they're here? Ma'am, what is your name?
Yeah.
There's a million Amandas. What's your last name? Okay, what are you here for?
Talk to the officer and just you here.
Okay, let's go get them set up. You're gonna go talk, you have a speeding or a civil infraction, right? Okay, go, she'll take you. Thank you. Stay seated, everybody.
Oh, so they're gonna.
I think there was 2 Woodhaven, wasn't there, and 1 Trenton?
Filed a motion to set it. Okay, people against James Donald Lambert, 260-648-142. Come on up to the podium, please. Good. Thanks. Good morning, sir. Your name?
James Lambert.
All right. You are going to plead responsible to impeding traffic, and they are going to dismiss the original charge of speeding, correct?
Correct.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
I'll accept your plea, dismiss the speeding, 150 is your total, and we'll write down to the cashier.
Thank you.
Have a good day. Thank you. All right, Kathy Mohammed Salah, 260-647-7753. Good morning, ma'am. Your name? All right, so you went into default. You filed a motion to set aside the default judgment. You posted a bond. They met with you and you were going to plead responsible to impeding traffic, correct? To that charge, responsible or not responsible?
Responsible.
All right, you got a couple, 3 on here, so 180 is your total. You have a bond of 165. Go down the hall, apply the bond, pay the other $15, and you're all set, okay? Good luck. Default judgment set aside on that, Heather. Default judgment set aside. Matthew Harris, 26W842021. Morning, sir. Your name?
Matthew Harris.
You are going to plead responsible to impeding traffic, correct? To that charge, responsible or not responsible?
Responsible.
I'll accept your plea. It's a first offense. 150 is your total. You're all set. Go down the hall and take care of that.
Thank you.
Best of luck. People against Baumia, Richard James Baumia, 26B150491. Your name?
Yeah.
You're going to plead to impeding, right?
Correct.
To that, and the failure to yield causing an accident will be dismissed, correct?
Correct.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, so it says no injuries, vehicles drivable, 195 is your total. Be careful though, okay? Good luck. The original charge is dismissed. People against Maxwell, Jacob Anthony Maxwell, 26B150524A and B. Good morning, your name? All right, so you're going to plead to impeding traffic. The careless will be dismissed. You're also going to plead to the equipment violation, true? All right, to that charge of impeding traffic on file A, responsible or not responsible? And to the equipment violation on file B, responsible or not responsible? Gotta be careful. You understand what I'm saying?
Yes.
Got you going, squealing tires, you went into the oncoming traffic lane according to the report. All right, I'll accept the plea to impeding 245 on that one, and I'm going to accept the plea to equipment violation. And that one, I'll charge you $135. You can go down the hall and pay those $260. You're all set. Good luck.
Thank-
I mean, $360. I'm sorry. People against Collins. Devin Tyler Collins, 25B149773A. Good morning, your name?
Downtown.
All right, Mr. Collins, you are on probation. And I have a charge here that alleges that you violated probation. I placed you on probation on the charge of operating while impaired. January 29 of 26. This charge, which would be your first technical violation, alleges that you did fail to refrain from consuming alcohol or drugs testing positive for cocaine on an April 1/26 chemical test. Do you understand the charge?
Yes, sir.
If you plead guilty or if you're found guilty, you could get 5 days in jail. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up both of those rights, and we are not going to have a hearing of any kind. Do you understand that? All right, you do have the right to an attorney if you cannot afford one. Either way, I'll be glad to appoint you one at public expense. Do you understand that?
Yes, sir.
Would you like an attorney?
Yes, sir.
I'm going to enter a not guilty plea. I will give you a lawyer. We'll set you up with the probation lawyer that just arrived, and we'll go from there. You also have a B file, by the way, where you pled the possession of a controlled substance, and the same thing exists on that. That would be a first violation, and that probation you could receive 5 days if you plead guilty or are found guilty of this offense. And since it was taken under section 7411, which I explained to you previously, that 7411 status could be revoked, the conviction entered, and you would be subject, like I said, to new sentencing and up to a 5-day jail term. Do you understand that?
Yes, sir.
All right. Any questions before I give you your lawyer? All right, go out in the hallway. We'll set you up with an attorney, and he will speak to you, and then you'll both come in together. Okay?
Thank you.
Morning, Miss Westmoreland.
Hey, good morning, Judge. How are you?
Good, thanks. How about yourself?
Good, good, thanks. Peter,
Tishkoff. Jenna Jolene Elizabeth Tishkoff, 26F24594950. Good morning, ma'am. Your name? All right, so, there's the probation attorney. You are charged with driving without due care and caution. There was an accident. Both vehicles were drivable. You have the right to meet with the department rep. We did do that. He's indicating both vehicles were drivable and there were no injuries. This says you are going to plead responsible for impeding traffic. Is that how you wish to proceed?
Yes, sir.
To that charge of impeding traffic, responsible or not responsible? Original charge is dismissed, 195. Cashier end of the hall to your right, okay?
Thank you.
Be careful, please. Suzette Kennedy West, 26F246992.
Judge, I believe that she came up to the window and just paid that. We were told there was no deal on that, and she came up to the window and was gonna pay it.
Okay, I'll just make a note. Defendant accepted responsibility, paid ticket. That was a charge of impeding traffic. Witz, Chad Austin Witz, 260-150-245. All right, good morning. Your name?
Chad West.
You are going to plead to prohibited parking, true?
Yeah.
To that charge, responsible or not responsible? Please accept it, $85. You are all set.
Thank you.
Have a good day. Original charge is dismissed. People against Stephen Chartrand. 26W41988. Your name?
Stephen Charter.
All right, you are going to plead responsible to impeding traffic. They're going to dismiss the 75 and 70. They got you at 85 and 70, correct?
Yes.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
Please accepted, 155 is your total. Cashier end of the hall to your right.
Thank you.
Good luck. I'm dismissing the limited access charge. Jonathan Samuels, 26W841995. All right, your name?
Jonathan Samuelson.
All right, they're dismissing us. You gotta have your plate up to date, though. You follow me? I mean, a lot of them wouldn't do this. I'll go along with it. It's an expired plate and it says it was 2 weeks old and you renewed it, so I'll go ahead and dismiss that on their motion. You're all set. Good luck.
Thank you.
Alicia Hartner, 26W841996. Your name, ma'am?
We're responding to this.
You gotta take it out of here. Get it out of the building, please.
Sir, you gotta take your hat off to leave the courtroom.
Ma'am, you gotta be careful.
Yes, sir.
I'm not sure I should take this. You got one out of Romulus that was an impeding traffic. I generally go back 7 years.
We'll see that I have not received any violations and.
I know, but you got, your record looks bad. You realize that, right? You got 1 in 20, a speed. You got another one in, hang on, let me finish. You got another one in 21 impeding that they probably wrote you for something else with, or you pled to impeding. Then you've got a speeding in 21. You got a speeding in 22, and now you've got this one.
I drive for a living slope, so I've kind of maintained that since.
Ma'am, I'm not sure you qualify for this. I'm gonna do it for you because I'm not gonna make assumptions on what happened on the other one, but you're gonna pay $195 to the charge impeding traffic, responsible or not responsible.
Responsible. I would ask that I, be able to pay $100 today and in 2 weeks the remainder.
$100 due now, totals $195, and you come back on May 11th. If you see my name on the ticket next time you get one here, you live in Woodhaven, you might want to consider I'm not taking impeding, okay? You gotta slow down, all right?
Good day.
You too. Kenneth Talton Jr., 260-647-651. Kenneth Talton.
Yes, Your
They didn't offer your name?
Honor.
They didn't offer you impeding traffic or what?
They did.
You don't want to do that?
I wasn't speeding.
They got you going 38 and a 25. It's okay. I mean, I'm not trying to talk you into it. If you don't think you were speeding, hang on, let me just finish here.
So,
I don't have a problem. If you don't think you were speeding, you shouldn't plead to anything. I'm only telling you, if you go to a hearing and you lose, you're going to get a point added to your traffic record. You've got a clean record now.
that's it.
Well, you got a 38 and a 25. I'm just telling you. If you think you were going 25 on Grange, that's fine.
Yeah, my only problem is he was before West. I was Angela. I feel like it's some obstruction.
If you think you weren't speeding, Grange is hard to go 25 on. I'm not going to lie to you. It's hard to go 25 on Grange. If you want a hearing, I'm not trying to talk you out of it. I want to be clear about that.
I'm coming before you.
You're coming before me.
You sound like you convinced that I'm guilty of.
I'm just saying they got you on radar going 38 and a 25. I'm not convinced of anything. I'm just trying to caution you. You want to go to a hearing and you lose, you're going to have a point. I'm not convinced of anything. You want to have a hearing? I'll be glad to give you a hearing. I'm not trying to talk you out of it. I don't want you to be blindsided here, because if you lose, you got a conviction on your record with a point. You want to set it for informal because you don't think you were speeding? No problem. I have no issue with that.
What's the fine?
I'm not going to negotiate with you. I'm reasonable.
No, I'm last.
I'm not going to negotiate with you. Okay? I know you're asking. This is a $135 ticket on a first offense with a clean record. In fact, I don't generally charge. I would charge $150. So that's as close as I'm going to come to talking to you about it otherwise. But if you want a hearing, please, sir, I'm not trying to talk you out of it. They're not always right. That's fine. You want to think about it?
I'll pay the fine.
No, I want to make sure that's what you want to do. Why don't you sit down and take a minute to think about it, okay? And then I'll call you. I will not keep you there. You go.
If I'm coming back before you, I'd rather pay.
Well, listen, don't make it sound like I'm not fair, because I'm fair. All right, so you don't have to. I'm just telling you somebody signed a ticket, an officer under oath, saying that we're going 38 and a 25. That's all. And you don't have to be going 38. If I'm convinced you're going 26 and a 25, you're going to be convicted of it.
Say I already felt that. So I just paid the fine. Pay the fine, sir. I felt like.
Listen, don't play this psychology. Let me stop. I'm going to be fair. That's what I do. But I don't make, you're already, no. I'm not convinced of anything. I'm just telling you, I got a police officer here. I got a clean record. I got signed a ticket on the road saying that you were going 38 and a 25. He might be crazy. Maybe you're going 3 and a 25. I don't know. I don't want to deter you. But I don't want to hear this stuff. I'm coming in front of you. You're already convinced. Please don't play that psychological garbage with me. I don't want to hear it. I'm just trying to be fair with you so you understand the consequences. If you want to go with a hearing, I'm going to be fair-minded. I'm going to listen to what he has to say. I'm gonna listen to what you have to say and I'm gonna make a determination. I just want you to understand that if you lose, you don't get impeding. That's what I'm trying to tell you. That's what they call plea bargaining.
Yes, sir.
Sit down and have a seat for a minute and think about it.
So,
Sit down, no, you want to go with the hearing?
wanna go with MP?
No, I don't, you haven't thought about it enough. Sit down and think about it. Sit down and think about it. I don't want you to walk out of here or anybody else to walk out of this building and say the guy wasn't fair with me. That's not what I'm about. I'm trying to be fair with you. That's why I told you what was up.
Yes, sir.
Have a seat. I'll be right back with you. I promise you. I'm not going to punish you by keeping you here. Joshua Aaron Frost, 260-647-510. Your name, sir?
Sure, Fox?
Okay, the child has to go out of the courtroom, please.
Get out. Okay.
I love children, but I can't have them in here yelling and screaming. Your name? You're going to plead to impeding, right?
Yes.
Responsible or not responsible? Disobey traffic signals dismissed. 150 is the total. Cash your end of the hall. You're all set. Good luck. Amanda Marie Frazier, 260-647-975. Your name?
Amanda Frazier,
Good morning. You're going to plead to impeding, correct? You've got a clean record to that charge, responsible or not responsible.
responsible.
Plea is accepted. Amber Light charge is dismissed. 150 is your total. You're all set. Go down to the cashier, make your payment. Best of luck to you.
Thank you.
People against Michael Andrew Depew, 216-648-063. Good morning. Your name? You're going to plead to impeding traffic, right? To that charge, responsible or not responsible?
Responsible.
All right, please accepted. 155, cashier end of the hall to your right. You're all set. Have a good day. And good luck to you. People against Hussein M. Boomrod, 26B150748. Good morning. Your name?
Sandy Marker.
You're going to plead to impeding traffic, correct?
Correct.
To that charge, responsible or not responsible? All right, you got to be careful, okay? 170 is your total. You got a couple entries on here. Be careful, all right? Cashier into the hall to your right and you're all set. Thank you. People against, can you put that back in? People against Shrivastava. Aman Shrivastava, 268842-165, A and B.
Oh, Judge, she's on Zoom. Somehow he got back into a breakout room. I'm trying to get him out.
Okay.
There he is.
Good morning, sir. Your name?
My name is Aman Shrivastava.
All right. So you want an informal hearing?
Yes, Your Honor, I wanted that, but I was trying to explain to the prosecutor before.
It's not the prosecutor. It's a department rep.
I was speaking with them. With him, and I was explaining that I had 160 slaughter hogs with me when I was traveling with the.
Slow down. You explaining to him what?
I had a live load of 160 slaughter hogs. I had livestock on board, and I had everyone was braking in front of me very hard, so I had to go in the left lane to momentarily pass the traffic. I was not traveling.
So you didn't want to take what he offered you, right?
He offered me out of 2 tickets, 1 ticket does not make sense because I had insurance.
Slow down. He offered you what?
He offered me impeding traffic ticket.
Okay, if you don't want to do that, that's fine. You got a commercial vehicle license, right?
Yes.
All right. Well, he's got you in the left lane, it sounds like. And you can't do that. So if you want to set an informal hearing, no problem. Just know that if you lose that, the points are getting assessed on your record. It's up to you.
I just want to add one thing, and
I
if
don't
you
want to
say,
add anything. I just want to know, is that what you want to do, is set it for informal hearing?
I'll pay for the impeding traffic.
Listen, again, I don't care what you do. These hearings take 5 minutes, 7 minutes. If you want to have a hearing, I'm not trying to dissuade you from that. It's up to you. I just want you to be aware that if you are convicted, that it's going to go on your record. That's all.
I understand that, and the only reason I wanted.
I don't need to know your reason. If you want an informal, I'll be happy to give you an informal, sir. I'm not trying to talk you out of it.
No, I understand that completely. Yeah, 100%.
Because somebody's kind of just accusing me in here of trying to talk them out of it, and that's the last thing I want to do. So do you want me to set it for informal?
Yeah. So no hearing. No hearing. I just want to pay for the charge I was offered for. That's all I want to do. Yeah. I'm not sure. I don't understand certain words, but I do understand that I don't want any hearing. I will go back to the administration representative.
I gotta send you back to the department rep, but I swear to you, I'm not trying to talk you out of going to a hearing. I want you to understand that.
Yes.
Okay?
Yes.
All right. That's what I'll do. I'll send it back to the department rep. That's got to go back to Woodhaven's. Kenneth Talton Jr., 26T 647-651.
Yes, Your Honor.
Your name?
Yes, Your Honor. Kenneth Thompson Jr.
What have you decided to do?
I'll second.
You sure?
Yes, sir.
I want to make sure, because I can promise you, if you are accepting impeding only because you think I'm not going to be fair with you, that's the last thing in the world that I want.
Yes, sir. I'm accepting.
You sure?
Yes.
You have to go back to the Trenton department, okay? Because he's written it up like he wanted to hear it. And that'll give you a couple more minutes. If you lose your mind, no problem. I swear to you, I'm not trying to talk you out of it. John, this one has to get back to Trenton rep. Okay? Thank you. You go back and talk to him. Thank you. Thornton. Lamar Eugene Thornton. 24B 702-123FY. That has to go back to the Trenton rep.
Okay, do I need to tell him anything about it, or
He wants some impeding now. Your name? So, here's where we are with this one. I find you. I placed you on probation for 24 months back on April 28 of 25. You have one prior technical violation. The charge here is now that you failed to pay your fines and costs as ordered of $1,115. If you plead guilty, if you're found guilty, that would be a second technical violation. You could receive 10 days. Do you understand that?
Yes.
And did you sign, read, and understand the advice and rights form here today? Plead guilty, you'll be giving up all those rights. We're not going to have a hearing of any kind. Do you understand that? All right. Give me 1 second here. All right. You have the right to a lawyer. I will be happy to provide you with one at public expense if you would like them. And you understand that if you plead guilty, you could get 10 days, right? You waive your right to a lawyer, is that true? To that charge then, that you failed to pay $1,115, your fines and costs as ordered, how do you wish to plead? Did you fail to pay your fines and costs as ordered?
Yep.
Has anybody forced you to plead guilty?
No.
And you're sure you want to waive your right to a lawyer?
Yes.
All right. Well, I'll accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted. Why didn't you come and talk to me?
For the most part, I was handling all
the previous warrant from my old ticket, so I just started, so mine got card, I started taking care of each one at a time.
Remember when I told you you were supposed to pay 50 per week beginning on September the 12th?
Yeah, then
Hey, slow down. Do you remember when I told you that? Did you do that?
my probation officer, she told me to focus on the ticket that.
Call in his probation officer.
What's the name on this one?
This is,
Miss Wild.
Lamar Thornton and it's Ms. Wild. She did, if you,
She had told me to pay off the Browns, basically that probation, because there was shoulders in. So I was focused on paying that, and I.
she gave you extra time and you paid nothing. Remember when I told you you needed to come talk to me if you didn't have the money?
Yeah.
You didn't do that, right?
Right.
This is now 6 months later, right? 7 months later?
I do want to know that I have each one of my courts that.
Sir, do you remember when I told you to come and talk to me if you didn't have the money? Why didn't you do that?
Just, my brain was just on another level, and I was trying to take care of what she asked me about. I thought I would be okay with just taking care of the probation and getting started and take care of it.
You know this is a 1-year misdemeanor, right?
Yes.
But I told you to come talk to me. Why didn't you come and talk to me?
I just, I wasn't thinking about it, so I just.
You weren't thinking about it. This
Yeah,
was your
I
hand.
was focused on too many courts at a time to where I actually didn't sit down to like, come and sit in here and advocate, to tell you that I was,
Your name?
Elizabeth West,
Did you tell him to take care of the other courts first?
he is scheduled to be off probation. He has a case with Judge Hessen. He missed his deferred judgment date. He had just paid that off in order for that case to be dismissed. So I did talk to him about making effort to pay to be able to get the warrants cleared that he had to get cleared as well. So.
Yeah, I know, but I told him to come and talk to me.
Yes.
And I don't want him talking to probation officers. I don't mind if there's a little leeway, but this one was 6 months. He hasn't paid anything on this. Where do you work?
Right now, I do my own business.
What kind of business?
Mostly I get my income from paying, but right now I'm converting the trailer into a food trailer.
Has he been doing his, did he clear all the other warrants?
Yeah, he's got a couple left to go, Your Honor. We were in court, back in September, allotted him a little bit more time. Every time I meet with Lamar, I do run his record and he's clearing them as we go. But it is the money that is surrounding, Mr. Thornton in regards to his ability to just close those out.
All right. Now, I want you to listen to me clearly. I'm going to give you an extension. I'm going to assess additional costs of only $50, even though it should be a lot worse. You haven't paid and you didn't come and talk to me like I told you. So I'm going to let you be the judge now. You're going to tell me when you can pay, how much you can pay on whatever basis that there is, whether it's weekly, bi-weekly, monthly, I don't care. You understand?
Yes.
When can you start to pay on this?
Stuff.
Tell you what, I'll just start having you pay $50 per week. And I won't even start it. I won't even start it until a week from Monday, which is May the 11th. Now, I don't have a problem with this. If you call the court and say, Judge, I don't have the money, you call the court at 8:30 on or before a due date, they'll set you up on Zoom. I'll be glad to give you 48 extensions if I need to. But you cannot ignore me like this. Do you understand that? I hope you do, because next time I'm not going to be this nice. When I offer people that, and then they don't come in here, I don't understand it. So I'm going to do this for you. No more. If you need more time, it's not an issue. How fair is that? Good luck. Lisa Kreider. 267-842-0063. Thank you. Good morning, ma'am. Your name? All right, so you're going to plead to impeding, right?
Yes.
You've got no priors to the charge of impeding traffic, responsible or not responsible?
Responsible.
All right. I'll accept the plea. 150 is your total, okay? 150 and you are all set. Your speed's dismissed. Good luck. Parker DeMarco, 26W42184. Good morning, sir. Your name? All right, so you're going to plead to impeding traffic, correct?
Yes, sir.
And they're going to dismiss the distracted to the charge of impeding traffic, responsible or not responsible?
Responsible.
Okay, I'm going to accept your plea of responsibility. Fines and costs are 155 and you, 160, I'm sorry, 160. And you are all set. Any questions?
No, sir.
All right, good luck to you. Thank you. People against Distad. Evan Curtis Distad, 26B150494. Your name?
Evan Curtis, this guy.
Yeah, you can't park over the sidewalk. You didn't know that?
I didn't know.
You can't do that. We're moving to dismiss it. I'm fine with it, but don't do it again, okay?
All right, appreciate it.
You're all set. Case dismissed. People against Erickson. Yvonne Rebecca Erickson, 26F246003, A and B. Your name?
Anderson.
All right. Detective, good morning. Your name?
Sir, Detective Judge Oda, police.
What do we have here?
Well, there's a little bit of confusion with the citation, right? Because Yvonne bought a vehicle in Ohio under the impression that all the registration, everything needs to be transferred. Unfortunately, she learned that's not true.
Wait a minute. Did you go to the Ohio Secretary of State?
Just the dealership. Yard dealership, that I bought the vehicle from. In Toledo.
Well, why would you think though that if you buy a vehicle, you don't have to get your plate renewed and not have insurance? You didn't call your agent?
Oh, no. Yeah, I definitely called the agent. Yes. So I got insurance. It was.
Yeah, but you didn't have insurance on March 30th, right?
No, I did technically. Two situations that were kind of weird. I know. First, the VIN didn't match the car that I was in, okay, which was a 2023, okay? And it said in the description it was a 2023 Jeep Grand Cherokee, but it wasn't the right VIN. So the dealership must have given me the wrong VIN because they get that all set up before you need.
Did you call your agent, your insurance agent?
I just do everything online, just type it in and everything was valid. It let me go through, had the same description. But
Wait a minute, slow down.
Oh, sorry, but
Slow down. I want to ask you a question. You can't leave the dealership without insurance on the car.
yeah, no, sir.
Did you call your agent and say, hey, listen, I'm getting a new car. I want you to put insurance on that?
Yes.
You did? Did
Yes.
he send you proof of insurance or she send you proof of?
Yes.
You have that proof of insurance with you?
I do,
Let me
yeah.
see it.
Oh, yeah.
It's in the package that I did.
The problem is the plate.
Hang on. Let me just look. So you went and got registration on March 31 of 26, the next day.
I transferred.
And you went to the Secretary of State, right?
Yeah.
When did you get the car?
In the summer, the prior summer,
Wait a
when
minute.
I was driving around my old plates.
You didn't even have insurance?
No, I did have insurance, it's just the plates didn't match. I know, it's a mess.
If you got the car in the summer, which would have been the summer of 25, why didn't you get registration and insurance? You didn't get your insurance. Am I missing something here? Can you try to help me out?
Well, Your Honor, part of the confusion where it started to become an issue for me was she was fully prepared to take responsibility for the expired plate. But when I started to address the insurance part of the citation, nothing about the vehicle on the citation matches anything to do with the paperwork that she's given. Because Officer Murray wrote her a citation based on a 2020 Jeep with a different license plate, and in the remarks section of the citation, the VIN that's listed there is completely different. So I stopped with negotiating with her because I wasn't sure exactly how to proceed based on the fact that everything she's given me is completely different than what she was issued at the time of the citation. So the stuff that she provided to us today is valid for the vehicle that she bought last summer, whenever it was, but.
Well, you kept the 20,000, you kept the, let me just see something here. You were still driving a 2020 car, right?
No, it showed that I was because the plate was still attached to my old vehicle. It was never transferred when I bought the new car to the new vehicle. That was the biggest issue. So that's why on a citation it has the 2020, because he pulled my license plate, which wasn't accurate to the vehicle I was driving. But then we discovered that even so, the VIN number on my insurance, even though the description says my new car, which is 2023 Grand Cherokee, was not the same VIN number as the vehicle I was driving. So the dealership must have given me the wrong VIN number when I did that, and then I never transferred the plates.
What do you want to do?
I'm perfectly fine with her accepting responsibility for the expired plate.
Are you dismissing the no insurance?
As long as the court is okay with it.
Is that what you want to do, ma'am?
I do, yeah.
Did you fill out a stipulated plea agreement?
Not yet, Your Honor. I was a little confused with the documentation, so I just was looking for some clarity before I did.
That's fine. If you want to do that, just write up, she's pleading the expired plate on file A and file B. You're moving to dismiss if that's what you want to do. Okay? I'll put that file right here. You can go write that up. Or I'll tell you what, I'll just give you the whole file. I don't want you to forget your registration or your other paperwork. So you can give her that after you fill out the form, okay? Thank you. Now I'm on Farhat, I'm sorry. 6F2460026. Good morning, sir. Your name?
Good morning. No,
I need your whole name.
no affirmative.
All right. So you met with the department rep, correct?
Yes,
And you are going to plead responsible to impeding traffic, correct?
yes,
They warned you on the no insurance and no registration. They're going to dismiss the speed. Do you have insurance now?
yes,
All right. To the charge of impeding traffic, how do you plead, responsible or not responsible?
responsible.
All right. I'm going to go ahead and accept the plea. I'm going to dismiss the original charge. 160 is your total. You're all set. Have a great day. Good luck. Bill Ampla, 267-842-2230.
Judge, he was on Zoom and he disconnected. I've been trying to call him and connect him back through to him.
Where's he out of?
I believe he was Pennsylvania.
I'll tell you what, let's just hope he logs back in, okay?
Okay, I'm gonna keep trying to call him also.
Good enough, thank you. People Against Genuine Justice, 26W842-172. Your name, ma'am?
Jenny Lynn Justice?
All right, so you are going to plead responsible to impeding traffic, correct?
Correct.
To that charge of impeding, responsible or not responsible?
Responsible.
Plea is accepted. The original charge of avoid traffic control device is dismissed. 155 is your total. You can go online and pay that, okay?
Okay. Thank you so much.
Best of luck to you. Thank you. People Against Talton Jr., Kenneth Talton Jr., 260-647-651. Your name, sir? All right, I'm going to ask you one more time. Are you sure you want to plead to impeding?
Yes, sir.
To that charge, responsible or not responsible? I'll accept the plea. 150 is your total. Cash your end of the hall to your right and you're all set. I wish you well. Good luck. People against? Victor Marlon Smith Jr., 266-48007 A and B. You have a no proof of insurance charge and you have an expired plate charge, your name.
Good morning, Your Honor. Get the law statement.
Good morning to you. You're going to plead to, you want an informal hearing?
Yeah, only because.
That's fine. You don't need to explain. We'll set an informal hearing. You can give me a date on these, Heather.
We can do May 11th at, take a look here, 9:45.
May 11th at 9:45. We'll summon the officer and we'll have our hearing on that date on those two charges. Any questions?
No, sir.
All right, wish you well. Good luck. All right. People against? And as soon as Ampaw comes in, Heather, I'll take him right after that next case, all right?
Okay.
Okay, is that the trooper?
That's the truth, yeah.
Yeah. Is he here?
They're all here.
Oh, I'll take that one next. People against Devin Tyler Collins, 25B1497773 A and B.
Morning, Your Honor. I was bringing forward MIDC attorney, page 657. I'm appearing with, Devin Tyler Collins, and when he left, would you please state your name for the record? Devin Tyler Collins.
I'm sorry, you're Mr. Green?
Yeah,
Okay, well, good to have you here. I don't think I've had the pleasure, have I?
that's been a while.
Okay, all right. So he's got a charge of failure to refrain from consuming alcohol or drugs testing positive for cocaine on April the 1st of 26. He has no prior violations. How is he going to proceed on this?
He admits that to the violation, he has had some stressful events in his life.
Okay, I'll take the plea and I'll listen to you, okay? How's that? And sir, do you understand what your lawyer just said?
Yes.
He tells me that you are going to be pleading guilty to the charge of testing positive for cocaine on a chemical test of April 1 of 26. Is that what you want to do? If you plead guilty again, you're subject to a 5-day jail term. Do you understand?
Yes, Your Honor.
And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial or a hearing of any kind. Do you understand that? I need Beth in here on that. To the charge, failure to refrain from consuming illegal controlled substances, testing positive for cocaine on a chemical test of April the 1st. How do you plead? Did you test positive for cocaine on that date, April 1 of 26?
Yes, Your Honor.
Did you consume cocaine within the, say, 5 days preceding that?
Yes.
Anybody force you to plead guilty? Plea is accepted to that charge. What were the circumstances?
Your Honor, Mr. Collins had just lost his great grandfather and also found out that a close cousin was going to federal prison for a lengthy stay, and became a little bit, I suppose, stressed out and of course sad, and that led to a relapse. He has paid all of his fines and costs as of 2 weeks ago, over $1,800. He's completed his victim impact class of $45 and paid $45 for that. He intends to enroll in drug abuse counseling at the Guidance Center in Southgate, Michigan. There's just been a little bit of confusion between whether his insurer, United Healthcare, will pay for it or whether he will have to pay out of pocket.
Why isn't he in there by now? I ordered January 29th for him to do outpatient treatment. I said AA 3 times a week until in treatment. Why hasn't he been in now?
He is an AA.
Yeah, I know, but why is it taking him so long? He's got to move.
Well, I do, okay, go ahead. That's the.
Not yet. Ms. Wild's your name.
Elizabeth Watson.
Can I see the screening report? Now you can say whatever you'd like to say.
I heard what I was told, and I thought I was able to have time until June 1st. That was also the time for the victim impact. So I thought I had the time to do that as well until then. But when I got on the phone call with my probation officer, she said that I needed to take care of that right away. And then when I started doing it, the my insurance is saying they cover it, and then the place says they don't cover it, but I'm at the point, where I'm just gonna pay out of pocket if nothing happens within the next couple of days. So I'm gonna be
Can't be fooling around with cocaine, and you did it at the time. You can't be doing that.
It's had a very bad relapse, very low.
Well, but you were doing it 2 times per week as of the date of the screening, and the screening took place after the plea. The screening took place on December 18th, so how's he doing with everything else?
Outside of the treatment, which he informed me he didn't have insurance, we actually referred him over to Wayne County Authority, so this is the first I'm hearing about anything with private insurance yard and the guidance center. But he did complete his court work program. This morning, he provided proof of completing his victim's impact panel. As counsel indicated, I do have his verification of his 12-step meetings.
Has he been going 3 times a week?
He has been, Your Honor.
In person?
In person, he does have his signature, Your Honor. I'm gonna indicate that what he's provided to me does make it seem like he's going in person, Your Honor. In regards to his testing, his test following the positive was negative. That was April 13th, Your Honor. He's due obviously for his next 2 chemical tests in the month of May. He's testing twice monthly.
Anything you want to say in addition?
No, that nothing that, Police officer hasn't, really provided. I think he did have a few plume test audits that before the failed test, and then of course the plume test after the failed test. He does keep a job 40 hours per week at a fencing company in Livonia. He's been there for 3 years. He's just trying to get this behind him to get moving forward.
I didn't really I didn't really set a time frame for him to be bi-weekly. Then I said then monthly, but I didn't set a time. I don't know if I did that wrong. I mean, if I didn't write it down or I neglected to say. Said bi-weekly and then I said bi-weekly, then monthly.
Yeah, I was leaving that to my discretion, Your Honor, when I see it like that. I did talk with Mr. Collins about reducing it, but not for a period of time, at least until he was in his treatment program, which again, is an indication he's not in it as of now.
You gotta get going. Suffice it to say, the reason I ordered treatment is so that this wouldn't happen. And you're not getting it taken care of. You follow me?
Yeah. My plan is to figure it out by the end of the day or the next couple of days, and if not, if my health insurance isn't gonna give me a straight answer, I'm just gonna play out of pocket and just start going.
Well, I wouldn't encourage you to do that. I'd encourage you to straighten that out with them. All right. Anything else, Ms. Wiles?
Nothing further, Your Honor. I mean, I know you have a second file, it's under 7411. There's continued use. I don't know if the court wants to enter that.
I'll keep that sitting out there, but if you mess up again, you're gonna have a big problem with me, okay? So I'll assess additional costs of 75. You're gonna do a day on the court work program and pay $35 for that. I'm putting all of that on the B file and I'm running it concurrent with the A file. And that's that, but you're gonna pay $35 for court work program, attend 1 day on the court work program, so pay additional costs of 75, continue testing bi-weekly until August 15 of 26. If you're clean, I'll then make it monthly. Okay? We understand one another?
Sir.
Good. All right. Anything else?
Nothing further, Your Honor.
Thank you very much.
Thank you, Judge.
Have a good day, sir. Good luck. Stay out of trouble. People against John Lawrence Wood, 26M 703 415 FY. Good morning. Trooper, your name?
Trooper Brown, Michigan State Police.
Good morning, sir. Sir, your name? Your name?
John
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf.
All right. So, for purposes of, he is charged with a felony charge of possession of cocaine, less than 25 grams per year. Does he stand mute, wait for a reading?
That's correct.
All right, so I'm going to enter a not guilty plea. I'm going to advise you of your rights, sir. You do have the right to remain silent. You do not have to say anything. If you say something in or out of court, orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to be represented by a lawyer today. You have the right to be represented by a lawyer at all subsequent court proceedings. If you cannot afford one, you can fill out a petition for one and I will appoint you one. You have the right to a probable cause conference within 14 days. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary examination, and you have the right to that within 7 days of the probable cause conference, the people have to show as to this crime that the crime was committed and that you were the one who probably committed the crime. If they prove that, you will be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, then the case would be dismissed and you would be discharged. Do you understand that?
Yes, sir.
And did you sign, read, and understand and advise? I'm sorry, that's it. Okay. May 12th will be the preliminary exam. I'm sorry, probable cause conference. May 12th at 9:30. May 19th at 11 will be the preliminary exam. So May 12th at 9:30, May the 19th at 11. So whoever's the officer in charge will have to be here for that. Do you want to address bonds?
Yes, Your Honor.
Go ahead.
No, but Mr. Wood currently is residing in Rockwood. He has no dependent matters. He's not on probation or parole. He is self-employed as a contractor. He's never failed to appear in court. He wasn't aware of this warrant at the time. But after speaking with Mr. Wood at length this morning, he did assure me he would be appearing all future court dates and understands the importance of doing so.
Cooper, can you tell me when or what his record's like?
He has, I believe, one prior for
drugs.
yes.
I believe it was dating back to 1990.
Yes, that sounds accurate.
All right. Do you have anything you want to say regarding bond?
I support the court proceeding.
All right. He lives on Hidden River Drive, correct?
Yes, sir.
They'll do prints over there today, right?
I printed him yesterday, sir.
Oh, you already printed them?
Yes.
Okay. I'll give you a $10,000 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I'm going to order that you attend AANA at least 2 times per week. That has to be in person. We're going to hand you a form every time you go. You have to have the form signed every time you come to court. You have to bring the form with you. No alcohol, no marijuana, no illegal drugs. AANA twice a week. You have to have the form signed. You have to go in person. You have to test weekly. So you're going to go to meet with probation. They're going to have you test weekly. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You understand everything I have said?
Yes, sir.
All right. So you're going to sit down there, fill out your petition for a court-appointed lawyer. He's going to hand you an AA sheet. Once you're done, you're going down the hall to get your new court dates and, your paper notes. Okay? Any questions? Just make sure you show up. Don't make it worse than it is. Good luck. Mateo Sands. Thank you. 26B149937. All right. Sir, your name?
Signs.
All right. So you got in an accident. It says you're going to plead to impeding. It says that there was, no injuries and both vehicles were drivable, right? To the charge of impeding, responsible or not responsible?
Responsible.
Plea is accepted. You got to be careful, son. 195 total. I'll dismiss the failure to stop assured clear distance. Okay. Good luck. Slow down. Be careful. Thank you. Aman.
Yes.
Rivastava, 26W8426165.
Yes, Your Honor.
All right. And hang on 1 second. Where's the other file?
Kim brought it back down. Somehow it ended up down here. I had her bring it down.
All right, well, no, you don't have to do that. Just make sure you make,
She brought it down, should be with it.
okay. So you're, Mr. Shrivasta, you have to start your video.
Yes, Your Honor. Yes, Your Honor.
Yeah. Okay, just tell me your name again.
My name is Aman Srivastav.
You're going to now plead to impeding traffic, correct?
Correct.
And that's with a commercial vehicle, and then they're going to dismiss the improper lane use, true?
True.
Is that what you wanted to?
Yes.
To that charge of impeding traffic, you plead
Yes.
responsible or not responsible?
Responsible, Your Honor.
Do you have that one? Shrivastana. I'm going to accept your plea, dismiss the commercial vehicle improper lane use. I'm going to dismiss the no proof of insurance. 235 is your total. Cashier end of the hall to your right, okay?
Okay.
Thank you.
I think that's the one
Thank
she
you.
put out there.
There's two files.
Right here on top. There's no.
Oh, okay. Sorry about that.
Can I
So you
pay
can go on,
this?
listen, you can go online and pay that today, 33court.com, okay?
Okay. Sorry, please say one more time.
You're gonna go online at
Yes.
33court.com, 33court.com. And you're gonna use your ticket number from the improper lane use, which has now been reduced to impeding traffic. And you're gonna pay your $235 on that, all right?
All right. Thank you, Your Honor.
Good luck to you. Slow down, be careful and all that. Good luck.
Thank you. Yeah, I will.
Do I have Erickson's files here? I got one file. I need the other one. Let me see.
They don't have paper clips on anybody.
That was the. And
Oh, wait a minute. Yes, I do. Hang on. Let me just double check and make sure you put that in there. All right. People against the bond, Rebecca Erickson, 26 F2460003A and B. All right, ma'am, your name? So you're gonna put the expired plate, they're going to dismiss the insurance, and you're gonna make sure you got everything taken care of, right? To that charge, expired plate, responsible or not responsible? Plea is accepted. I'm gonna go ahead and dismiss the no insurance on motion there. Police officer, 135 is your total. You go down the hall to the cashier and make your payment. Good luck. You're welcome. All right. Is Ariana White here? Come on up here, ma'am. I'm sorry. Ariana Carey White, 216-647-629. Your name? All right. You're going to plead to no proof of insurance? To that charge, responsible or not responsible? Do you have insurance now? You can't drive without insurance, man. You get in an accident, that'll haunt you forever. You follow me? The insurance company will pay the damage to the other car and wage loss and whatever else, then they're gonna come after you. And it's not gonna be fun. 185. You gotta go get insurance. Gotta go get insurance. You go down the hall, make your payment, you're all set. Good luck. People against Drew Deshaun Grayson, 25G719-663. Your name?
Lou Grayson.
Did you meet with a lawyer this morning?
No, I'm supposed to. I usually do more.
We're gonna take you to the probation lawyer, okay? So he's gonna set you up. My court officer is, and then you're gonna go talk to the lawyer, and then the two of you are going to come in front of me, all right?
Yeah, come on.
Any questions?
So,
Good luck. Zachary Dodds, Zachary Ryan Dodd, 26F245888. Your name?
Zach, Dodd.
Mr. Dodd, what's going on with you?
Doing very well. Just made a mistake and ended up giving myself a ticket.
Huh? You're to plead impeding, right? Responsible or not responsible? 150 is your total, cashier end of the hall to your right, and you're all
I
set.
do have a favor to ask you.
A favor?
I am currently in between job. I have to start my,
When do you need to, how much time?
could I have till end of this month?
You're That's only 2 days.
Oh, sorry, kind of, May.
Where are you starting in?
CA Hall, I'm gonna be built in Bridges for the state of Michigan. Yeah,
Good.
I was trying to let go from a risky union job and I just paid my mortgage and it's just been tough this month.
Okay, $75 bi-weekly, beginning on May the 18th, okay?
Thank you so much, Brandon.
If you need more time, call the court. We'll go on Zoom. I'll give you an extension. Don't be bashful.
No, I won't.
Just don't ignore me, okay?
All right, thank you.
Good luck. Jackie Lee Hughes, this one goes to.
The night before Thanksgiving, my son, Jake Villani, was leaving work at Dorothy Lane Market, looking forward to spending the holiday with his family. Jake is a careful, responsible young man who always follows the rules. He waited for the crosswalk signal, doing everything right, completely unaware that his life was about to change because of a choice someone else made. When Janet Kenfield chose to drink or to drive after drinking, she struck Jake and left him lying helpless in the cold, dark street, unable to move or call for help. I was awakened by calls and messages telling me that my sweet boy, who ironically doesn't even drink alcohol, was in the emergency room. When I arrived, I learned he needed emergency surgery to repair a severely broken hip. The amount of pain he was in was overwhelming to witness. So many lives were affected by this incident, far beyond just Jake's. I had to take a significant amount of time off work to care for him, which meant my coworkers had to rearrange their schedules and take on additional responsibilities. Jake's brother and sister spent much of their free time helping him with basic tasks he could no longer do on his own. Our entire network of family and friends was shaken by what happened. Many of them were emotionally traumatized, worried constantly about Jake's recovery and our family's well-being. People went out of their way to visit, bring meals, and offer support, trying to ease the burden in any way they could. Their kindness meant a great deal, but it also underscored how deeply this incident disrupted all of our lives. This experience not only saddened me, but made me angry. I want justice for my son who never deserved to be in this situation. Learning that the person responsible for Jake's injuries is not accepting responsibility and not able to be held fully accountable has been incredibly painful for our family. It's added a layer of frustration and disbelief on top of the trauma we were already navigating. Ultimately, we know that Mrs. Kenfield caused this to happen to my Jake. Regardless of the concessions being made on her behalf, I want her to know that Jake is a kind-hearted, hardworking, wise beyond his years, 24-year-old young man that she impacted physically, mentally, and spiritually. I don't know if I'd be able to say this if Jake hadn't survived this incident, but I forgave you a long time ago. I've made unwise decisions in my life, but by God's grace, I didn't cause this much affliction to anyone. I thank God too many times to count for sparing my son. I thank God too many times to count for not sparing his son, Jesus. As a very young boy, Jake made the decision to trust Jesus as his savior. He never expected his life to be easy or perfect, but he never anticipated the pain either. The beauty of a relationship with Christ is no matter what life brings us, there's a higher purpose, and there can be peace in the purpose, no matter how painful. If Jake and our family went through this misery just to tell you and your family, Janet, that Jesus forgives you, he sees you, and he wants you to know him, we found our purpose.
Nicholson, is there anything else?
No, Your Honor.
Mr. Rubenstein, is there anything on behalf of the defendant?
Judge will submit on the written motions. Thank you.
All right, at this time, ma'am, I do feel your pain. It is somewhat frustrating, but I would suggest perhaps that if you wanted to make a change, that you reach out to your state rep or senator, state senator, to make a change in the way the statute is worded. I guess I was somewhat surprised to learn that this is not considered an offense of violence. I guess from your perspective, it is clearly an offense of violence, the way your son was injured, but it is not. So the court does not have any choice at this time but to grant the defendant's request and dismiss the indictment. I would encourage Jake. As you know, Jake, all things work for good for those who love God, who are called according to his purpose. So he has a plan for you. Okay? That's all. Thank you all.
And we'll order the return of the vehicle.
Yes, that'll be granted as well. Thank you.
Thank you, Judge.
Talk to Alan.
For Edward Hedge. Pardon the responding officer. I just want to put it in my note purpose. It just deputy.
What is she?
Have you know? I'm sorry.
Court does call the case, People versus Edward Harvey.
And on behalf of the people, Your Honor.
And Stephanie Can on behalf of Mr. Harvey, who's appearing. Could you say your name for the record?
Edward Harvey.
Your Honor, today's the date time set for the examination. At this time, for unable to proceed as to count one, would ask for count two to be remanded down to district court.
Your Honor, we have no objection to count two being dismissed.
Count one. Count one being dismissed.
Yes, count one to be dismissed, yes, Your Honor. Count two can't be dismissed.
What's the beginning of the count one? Count one is dismissed. I'll continue the defendant's not guilty plea to count two. Set pretrial in this matter for
May 7th at 9 a.m.
May 7th, 2026, 9 a.m. before Judge Barr.
Thank you, Your Honor. Your Honor, my client has made a request that with the felony being dismissed, if the court would be inclined to allow for his own privileges to be reinstated. As the court is aware, he initially revoked his privileges based on some communication. I believe information and emails have been received by the prosecutor letting them know that the complaining witness is not willing to move forward on this. And that at that point, she believed that she had anxiety and a psychological issue. It was an email I received, which was what led to this. So we're just asking that his privileges be.
But his privileges were revoked because the underlying offense was to domestic violence.
Yes, Your Honor.
So that hasn't changed.
Yes, Your Honor, that is correct. That is being remanded down to district court.
Is there a response from the people?
Violated no contact order with the victim by falling during community. Why don't ask their major votes.
Motion for bond modification is denied. Bond will continue and his phone privileges remain revoked.
Thank you.
Bond will continue. Thank you.
Thank you, Your Honor.
Was the rabbit.
And the other one was on your second page. It was Roger. Now sure that they're ready on this one is stuff on me.
Fernandez, and that's why we got that.
That's why it's still here. Sure. I'm gonna go back over here. Somebody over here. And Jesus.
What?
Okay.
Things a whole.
That's
Miss Gaines.
Yeah.
And then what are we doing on the other one?
But the question is, what are we doing under Candace?
Hernandez. So the prosecutor has brought some information to my attention regarding potential bond violations. It's a waiver. The underlying matter would be waived, but I need to see what she has because my client has shown me his phone and he's saying that that's not him. So I need to see what she has.
And I also am having a deputy do a follow-up interview with the victim, on these contacts. He's here. They should be doing it right now. Or,
Okay, so somebody's doing a follow-up interview.
yes, to get a little more information on these potential law violations.
How can they get out?
Oh.
That was fantastic.
I don't know. I don't know why. I don't know. No, you can stay. That was my initial reaction. Okay, so you need time on that.
Yes.
All right, so that's on. And just so you can let me know as soon as possible, because we do have an interpreter here on that.
Yes, I'm going to go work with him right now.
With him, okay. And then the other matter, King, wherever Miss Gaines is, that's gonna be a hold.
Correct, Your Honor. Hold for the aspect of continuance.
Okay. Can be as exciting as the last time he was here.
I'm doing this case in the other court. I can go right after.
Well, no, the quick, do you do anything? What? No, I don't know. He just walked in and then he's just like trying to help.
Shame on him.
I know.
He's right. He did tell me to stay here.
I did. I told you don't come in. You stayed. I stay here and then you went. You know, if you follow instructions, we wouldn't have this problem. All right. No. I'm sure. Well, is she in the middle of something? No. No? All right. Let me tell her to be prepared to go. I'm going to take a brief break again and then we'll come back in and that's all I've got plus this one. All right. We're staying in recess. Mirage.
Okay.
No.
But the video working on half of this. Original decision for the record.
Maybe seated. The preliminary examination, are we ready to?
President Preliminary Commission, and this is anything where after the first of the asking for continuance, given that there's luminous amount of discovery that I have not even been able to review as we received it this weekend, and that defense counsel does not have yet. I created a discovery packet for it yesterday. The court, as you may remember, set this exam last week, and informed the people that they may be able to start or continue the exam based on that. I have concerns given that this discovery includes potential video or surveillance footage of the assault, the victim's medical records, follow-up interviews with the victim and the victim's mother, and then the contact that would be jail calls and screenshots as well of outside contact. And I have not had a chance to review any of that, and I don't defense counsel has either. So this time I'll be asking to start the exam with one of our officers, and then it's given that.
This game.
Yeah, so first of all, I have explained all of that to my client, and he is aware that I have started listening to the jail calls, that I do not have the medical records, and that
Go ahead.
and that
But just so that I'm clear, these are medical records regarding the child. Oh, boy.
that is true. Anyway, so I have received and looked at some, but I have not received all and have not been able to get through all. He is aware of that. He believes that this is, he objects to the preliminary examination as well as to a continuance because this is the date and time scheduled for the preliminary exam. If the people are not ready, then a dismissal today does not harm the people. A dismissal would allow them to continue their investigation and get all the information they need and not deprive them of his liberty rights while they continue the investigation, as opposed to being ready in the statutory framework.
And you're, just for the record, the case was dismissed today, the people will be reauthorizing.
Yeah, I mean, that's what I was just gonna say. I mean, the reality of it, which is why when people are trying to rush things, it doesn't always work. If I grant your request, your client would understand that, let's say I dismiss it. Within a matter of minutes, before he even goes downstairs, they're gonna be back here and it's gonna be reauthorized. And then the whole clock starts again.
Not aware of that. So he acknowledges that and has not asked any question. The other point to our request for a dismissal at this time is that we believe that they are proceeding in this fashion because they are in fact not ready with regards to all of their witnesses.
I'm sorry, say again.
That they are not ready with regard to all of their witnesses, specifically the complainant, and that this is to prolong this.
Wants to.
He does have.
No, go ahead. Just make sure to hit gonna talk to, yeah, just make sure to hit that.
Yeah, his next question, and I did say that, and I did not get a chance to find out when the next available date for court, because if the court is going to grant the response, he's asking for the shortest possible.
Right, and I just so that you're aware, counsel kind of let me know that this might be happening. And so I was looking back there. I didn't know entirely what the defense's position would be. And maybe so that you compare the two. I'd say that if I did, today is the 28th. If I dismissed it, swore it out, reauthorized it today, he wouldn't get a PCC until the 7th or the 14th of May. And then an exam would be set after that. So you'd be looking somewhere around the 19th is the quickest that I could probably do with either one of them, right? So it'd be the 19th. Safely, you could look at it if we went that route around the 19th. I could, and I got dates sooner than that. But then the question becomes, with the information that, go ahead, Ms. Gates, he's trying to tell you something.
Please,
Okay. With the information that's coming in, you said it's voluminous. So how fast can somebody legitimately get through that information? Because Ms. Gaines has not seen it, hasn't shared it with the client.
I would think for my review and then being able to, I would make sure that it gets to defense counsel today. There is a disc that needs to be picked up from our office. But the discovery as part of the subs and the evidence on how I would think 2 or 3 weeks at the most.
2 or 3 weeks at the most.
I think 2 or 3 weeks would be appropriate to give me time to go through the subs and the media that has come in.
And Ms. Gaines, you don't have an idea because you don't have it, right?
Correct, I'm not. No, can't say how long something, those things. Can't say that I am viewed. I don't know if it's all of the ATM video that I am anticipating will be, some of the supplemental reports, but I do not,
You don't have the reports, but you reviewed body cam that may constitute those. Is
that is,
that what you're, okay.
I don't know if that's all of it, but that I have reviewed.
So is the big part of the packet that you're talking about, is that medical?
Well, there's medical record jar, there's also surveillance video from the Walmart and the Meijer in regards to the assault in the parking lot. And then there's also a follow-up interview that was done with the victim and the victim's mother. And then one of those stuff also the jail calls, kind of parse them through. That is, and that's what it is.
And I did see what I believe is a bit in, was able to show my client what is the video for Walmart. I did not see video for Meijer, so that would be video that you have not received yet, or
That's how it gets.
So the Walmart, we're just taking that piece, the Walmart video has been turned over. You've been able to show that to Mr. King. The other video, you haven't been able to show it to him.
yes.
Not about being turned that yet.
Correct.
Part of my concern on Thursday. I haven't really been able to review any of the additional discovery that we received yet.
Well, I'd frame it this way. If I'm looking at if it were dismissed, reauthorized, they'd be on the 19. I'm also trying to balance everybody being able to look at it, Mr. King being able to see everything. And I'm going based upon the representations of the information that's there and being able to process it. All right. If I went to it doesn't sound to me like everybody's going to be able to get through this in 6 days, right? So then the next choice, I'll cancel or move stuff. I can do the 12th, not my normal day. I can do the 12th at 1, which would be a week off of when I would do it if it were dismissed.
We had Judge Company's program, maybe I could send the disc to one of these there to bring back to these today as well. So they don't have to.
Got it. So they don't have to come over and get it. You can get it to them.
Correct. If that would be easier.
You can get it to them today, the disc part. They don't have to go over and pick it up. Okay.
And I'll make sure that subs and other things from Cartel is sent over today as well. So everything hopefully should be over today. I can have my.
That's where we would be, because the problem is if I set it for the 4th, we're going to get back here, we're going to have the same darn problem. And so the bottom line is given what everybody's told me, I can speed it up a week from what would be a dismissal. Ideally, even if we proceeded with the one witness today, began it, then I wouldn't adjourn it out past that same date, the 12th. So that's where we are.
So he is objecting to the 12th. He would like to either have it dismissed today or to have an early.
I doesn't get the dismissal. I mean, that's the problem. So, rather than going around, I don't have to try to accommodate anything. I can just have them call their witness, do it, and then I can adjourn it out to whenever I want to. I mean, I'm trying to get him in as fast as I possibly can, but I'm not, if I'm gonna be hard-headed about it, I'm not gonna deal with it. So here's what I'm gonna do. You need to turn around. You can take him back this game. You can talk to him. You can decide then what you want to do, and then I'll make my call on it.
Thank you.
What's the matter? Ooh, that was fun. You ready on the other one? Okay, then why don't you find her? I'm gonna step back and then I'll talk to you guys. Court standard. All rise.
Jackie Lee Hughes, 26F246012. Morning, Mr. Hughes. Your name? You're going to plead to impeding traffic, right?
Yes, sir.
You gotta be careful out there.
Yeah.
You're close to not being given impeding here. You understand what I'm telling you? Yes? To the charge impeding traffic, responsible or not responsible?
Responsible.
Please accepted. One, these are total. You can go down the hall and take care of that. Good luck. Sir, if you can see my name on the ticket next time, you're not getting impeding from me. Got it?
Sir.
Good. Race Robert Loving.
Judge, I'm sorry, how much was it for that one? I missed you.
190. 190.
Thank you.
Race Robert Loving. 26T647698. Defendant failed to appear. Defendant is responsible as charged by default. Case was scheduled for 10. It's 10:47 rather. Eman Yelazarov, 26F246010. Morning, Mr. Yelazarov. Your name?
Good morning. What's that? I'm in
All right, so you're going to plead to impeding traffic, correct?
Correct.
To that charge, responsible or not responsible?
Responsible.
All right. Please accept it. 155 is your total. Cashier enter the hall to your right and you're all set. Good luck.
Thank you so much.
Augusto Contreras Hernandez, 26W841323. Defendant failed to appear. Defendant is responsible as charged by default. Oh, wait a minute. Who's the officer on this one? Is Officer Villarreal here?
Officer Villarreal is not here.
Come on up here a second. This was set for an informal hearing.
Yeah, that's what I thought.
Your name?
Woodhaven Police Department.
Neither one of them showed, and I just don't feel comfortable. I'm gonna have to go ahead and dismiss the ticket.
I do have an iPhone. I'm not finding this name that just zoomed.
From D. August or something like that. You gotta identify yourself. What's your name?
Me?
Yeah.
Augusto Contreras Hernandez.
There he is.
Okay. Plaintiff failed to appear. I'm dismissing your case. Case dismissed. Defendant, PO failed to appear. You're all set. Good luck.
Appreciate it, Your Honor.
Thank you.
Thank you so much.
Lieutenant. Have a good day.
You too, man.
Take care. Bye now.
Bye.
Has Bill Lampaw ever showed up again?
No, and I have called him multiple times. It goes straight to his voicemail.
I can't, Tristan Gage Helms, 26F 246-008 and 009. Your name?
Tristan Gage Helms.
No, I just have 26, my mistake, forgive me. This is 26F 246-009. I'm sorry, your name again.
Tristan Gage Helms.
All right, you're going to plead to impeding traffic, correct?
Yes,
To that charge, responsible or not responsible?
responsible, sir.
I'll accept the plea, 150 is your total. Cash you under the hold of your right, and you're all set. Good luck.
Thank you, Your Honor.
All right. Norma Graziella Rodriguez, 26F 246-008. Defendant failed to appear. Defendant is responsible, is charged by default. And I don't know what to do with AMPA. They worked it out where he was going to plead on file A.
And I just tried him again and got voicemail again.
You know what? This is what I'm gonna do. I'll just make a note here because the charge was impeding traffic. I'll just make a note. Parties worked out agreement. Defendant here by Zoom lost contact. He never reconnected. So what I'm going to do is I'm just going to go ahead and I'll just make a note. C stick. Defendant was to plead to as charged on file B. And the prosecutor or the department rep was going to go ahead and dismiss the A file defective equipment. So no harm, no foul. I'll go ahead and take the plea. I'm going to assess fines and costs on the impeding of $155. You're going to have to send him something and tell him that he has to pay this by whatever, May the 14th or something in that area. I don't care what date you pick out. And I'll still go ahead and dismiss. I'll say C-stip, CB file. That was the impeding traffic file, and I'll go ahead and still dismiss the defective equipment. So that's what I'll do. So he's still going to end up with the same bargain that they worked out with the department rep. Is Mr. Green with that guy?
Who's that?
The probation file I gave you?
Grayson?
I don't know. Was it? Do you have anything else down there? All right, court's in recess.
Or John Kaneta Brown. And you're here with Mr. Dusler, your attorney. You're charged here with third-degree felony of theft. And I believe this is going to be disposed of by her paying restitution.
Yes, sir. She's been paying on it, and there may be a little question.
How much is still left?
We're not sure exactly.
she's brought a piece of paper that said that the civil part says that she owes $400 something. Our record show she owes $2,300 more. So we gotta get that cleared up. I can't tell where that came from. I gotta call the people myself.
It can,
Does it say, it says you paid something to it, right? But it doesn't say how much the amount is left, does it?
yes,
What does it say? Or- Balance of $2,076, not 400, which is what he was trying to tell me. So,
Is that what the document says that she's holding?
That's what the document says.
Okay.
The problem on this, Judge, is this is U-Haul. And that U-Haul has been taking payments from her directly, and she's also been making payments to the district attorney's office. So there's been a dispute as to how much she's paid each person.
But it's math. You have to be able to figure that out. It's math.
But anyway, I guess for today, if we can just get one more reset and hopefully
2
we
weeks.
can.
Can we come back in 2 weeks on this?
I'm good with it.
Thanks.
Yes, sir.
Okay. Ebony Chapman?
Chapman.
Yes, this.
This is 205.
we haven't been able to travel to work.
I'm getting part of
Ma'am.
205.
All right.
Sorry.
We'll do something else while y'all are waiting on that. Caitlin Lewis.
That's please, well, Your Honor.
Can't see him.
Is that also held up?
Yes,
Yes, I'm just getting part of it.
Ashley Otem.
That's not mine. Mr. Kimler's taking over that one.
That's been reset. She hired us.
That's been reset.
Yes.
James Hoskinson is
That was
reset. Andrew Lakey is reset. Why are all these being reset? All Galmos?
Judge, Mr. Galmore had to be in Houston, so he had to leave by 10 o'clock. But it's a quick one reset. I have the files, Judge.
You want to take a picture or everything?
It was already done, but I can do a setting.
Thank you.
Okay, so we're at Ebony Chapman and Kaylin Lewis.
Yes.
Who's reset before? Who's reset before?
I'm not sure. I'm not the one that did the resetting. So.
Okay.
Sorry. Thank you.
My son, both of them.
Chapman? Ms. Chapman, come on in. Oh, right up there in the middle. 25 CR 1847 is called the State of Texas versus Ebony Chapman. That is you.
Yes.
Present with Mr. Deusley, your attorney, and the state's attorney. And does the defendant waive a formal reading of the indictment and the arraignment here? That's blocked. Can we proceed in summary?
Yes, sir.
In summary, paragraph 1 of this indictment alleges that on or about August 26, 2025, in Jefferson County, Texas, you committed the state jail felony of theft. And it's a state jail felony because even though the value was less than $2,500 in accordance with allegation paragraph 1, paragraph 2 goes on to have 2 or more prior convictions in county courts at law of thefts. Thus, paragraphs 1 and 2 constitute a state jail felony. Do you understand what you're charged with here?
Yes, sir.
A state jail felony carries with it, if convicted, no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Is that your understanding of the punishment range?
Yes.
What is the plan?
The agreement is 2 year state jail to be probated to whatever length of time you feel is appropriate with a $500 fine. No restitution.
Is that your understanding of the agreement?
Yes, sir.
All right, if I follow that agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead then to paragraphs 1 and 2 of this indictment? Are you guilty of paragraph 1 and or those prior convictions listed in paragraph 2 out of Orange County, Jefferson County, and Calcasieu Parish of thefts? Are those true and correct as they are alleged?
Yes, sir.
Are you pleading true and correct to all of this voluntarily and because it is true?
Yes, sir.
Yeah. I'll show you what's marked as State's Exhibit 1 here. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered without objection.
No objection.
It is made a part of the record for all purposes. In summary, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights through jury trial and the rights to appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, yes, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Also, the agreement here is that you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation, which can be up to 5 years in length, fined $500. I've got restitution here in there, but
There's no restitution.
there's no restitution. Is this your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty, in this indictment in paragraphs 1 and 2?
Yes, sir.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Pre-sentence report is waived. I'm going to follow this agreement. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1, which is made a part of the record in this hearing for all purposes, to find you guilty beyond a reasonable doubt. I now find you guilty of the state jail felony of theft, and I'm following this agreement. You hear my sentence to confinement in the state jail for 2 years. That confinement is suspended. You were placed on regular probation for 5 years. Do well, it will be shortened to a third. And a fine of $500 will be assessed. A third of 5 is about 1 2/3 of a year, so could be less than 2 years. I am signing these documents here. These are the probation orders. It consists of 3 pages. There are 36 conditions and requirements, including you must complete a theft prevention class. Almost all of these requirements are a requirement all of us have to follow, beginning with don't commit an offense. Don't associate with conservative activity. Support your dependents. Ensure that you don't possess drugs and use drugs. I mean, all of these are the kinds of things that we all have to follow. So it's a good thing to begin writing and you get to know what the requirements are. Please follow these. At the end, you do well, then probation will be terminated. Oh, to be early. If you fail, your probation could be revoked and you could be sentenced up to 2 years in the state jail. Do you understand what's riding on us? Okay. Please see the probation officer. Thank you very much. Good luck, man. All right, next is. Have any chats? I'm sorry, Kaylin Lewis. Looking at his name right here. Kaylin, chatting. Kaylin Lewis. And. Yes, of course. Yeah.
Thank you.
26 CR 300 is now called. You are Kaylin Chanel Lewis, present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, paragraph 1 of this indictment alleges that on or about February 16, 2025, in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege, though, that you have been convicted of at least two prior DWI driving while intoxicated offenses. One on August 18, 2015, out of the County Court of Law 2 of Jefferson County, Texas, and another August 27, 2021, in the County Court of Law number 3 of Jefferson County, Texas. Paragraphs 1 and 2 constitute a third-degree felony. 2 or more prior DWI convictions, and you commit a third one, it becomes a felony. Do you understand what you are charged with here? If convicted, they got her as an habitual offender. That can't be right. We need to fix this. This is a third-degree felony. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty and sentenced to 10 years in prison. That sentence would be suspended. You would be placed on regular probation for up to 10 years and live. You must pay a fine of $500. Also, as a condition of probation, you have to spend at least 10 days in the county jail. Do you understand all of this?
Yes.
And is this your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this indictment? Guilty or not guilty?
Guilty.
You have a soft voice. What'd you say?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty of what this alleges. And you're guilty.
Yes.
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 I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney?
Yes, sir.
Are the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence. No, without objection, admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true as state, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. How do you plead to paragraph 1 charging you with the DWI operating a motor vehicle in a public place while intoxicated or about February 16th, 2025 in Jefferson County, Texas? Guilty or not guilty?
Guilty.
And paragraph 2, which alleges those prior convictions of DWIs in 2015 and 2021 out of County Courts of Law of Jefferson County, Texas. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to that? Voluntarily and because it is true.
Yes, sir.
Pre-sentence report ready?
Yes, sir, it is.
I'm going to follow this agreement and find you are pleading guilty voluntarily and truly to paragraphs 1 and 2, which constitute the third-degree felony of operating a motor vehicle while intoxicated. And you're doing that voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony as presented in paragraphs 1 and 2 of this indictment. Following this agreement, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That sentence of confinement shall be suspended. You are placed on regular probation for 10 years. It will be shortened if you do well on probation. You must pay a fine of $500. And also, as a condition of probation, you must serve at least 10 days in the county jail. So you will serve 10 days in the county jail on weekends. And I believe the parties have agreed this will begin on May 8th. Is that a Friday?
Yes, it's Friday of next week.
And you will report each Friday thereafter on or before 6:00 p.m. They release you at 6:00 on Sunday. You get 2 days credit, so you're going to have to do 5 weekends in consecutive fashion. Now, there are terms and conditions of probation, and you heard me talk to the previous defendant, which are there's a fine of $500. That there are several 36 conditions which you must follow, but most of these conditions are conditions we all have to follow. There are certain specific ones that are particular for this type of offense. The probation officer is going to go over with you all of this. Please follow these conditions of probation. If you fail, your probation can be revoked and you can be sentenced up to 10 years in prison. So we don't look at that.
It's too much each on with all the heated loss conditions.
Yeah, okay. Stand on. Here's this. Thank you.
Thank you, Judge.
Do you date these or do I on these additional terms? The date here. Okay, once you go over with the defendant and she signs, thank you. And this, you must have an auto ignition interlock system installed in any vehicle you operate. Also, you must complete a Texas DWI repeat offender program and pay the associated costs. And I believe this cuts both ways. I believe that program also results in a discount for your insurance. It helps you on your automobile insurance. That will raise because of this offense. And I think this brings it down a little bit, so it makes it tolerable. But that's the price we pay when we, make a mistake. Fix it. This is one of those things you need to fix. This is your third one. How are we doing with the alcohol issue? Do you have that under control? Okay. Please act responsibly. I know you're able to. Okay. Thank you. That is all the issues. Anything else on this? Then we are going to see our jury. I looked at these and I thought they were all down. Xavier Curtis. And then there's a Simeon. Who's representing Miss Simeon?
That's just one initial, Judge.
Okay. Okay. Xavier Curtis. Is that right?
I'm concerned.
Yes.
I've got to go to federal court, so I'm gonna go ahead and send the jury and then recall your docket.
Can you give me 5 minutes?
Yes, Judge.
Oh, no more.
Judge Clifford, great.
So,
Yes.
Something supposed to be off the vote. Hey, I'm going to.
We're going to be handling some matters including seating the jury, so we're going to go offline and we will be back for the beginning of the jury trial this afternoon.
1 o'clock.
Is that this afternoon? Not 1 o'clock AM. We're looking.
Just a couple matters of housekeeping. I've already spoken to the prosecutor about this. There are 4 body cam videos that I'm assuming may or may not be evidence. Those body cam videos do contain some discussion.
Leo Williams.
Would voir dire to give me the facts that support a plea?
Yes, Your Honor. Mr. Lane,
Yeah, go ahead.
Mr. Lane, on December 19th, 2025, were you at a residence in Huron Township? And is that within the county of Wayne? Yes. And during that time, there was a dispute with property you were collecting in your divorce, correct? You were in your pole barn or attempting to go into the shed. And when you attempted to go into the shed, at some point in time, you have contact with your now ex-wife. Okay. And in the process of opening up the shed door, your ex-wife is Heather Lane. Yes. And prior to opening up that door made contact or hit Miss Lane, causing her to trip. Right.
You satisfied, Mr. Lucky?
I walked in midway. Did we get the location?
Yeah, what's your own township?
I'm satisfied.
Okay, satisfied? I'll accept the plea. Gentlemen, I'm inclined on these cases to send for a pre-sentence investigation.
I do know the complaining that is present. Willing to speak, but not at this time, so it makes sense.
Yeah, that's good. Probation will reach out to them. All right, so I've accepted the plea. Mr. Lane, I'm going to continue your bond, send you downstairs. You'll make an interview date with the probation department. You'll come back and be interviewed. Based on that interview, the probation officer will prepare a report and a recommendation for sentencing. When you get back for sentencing, whenever that's going to be, you'll find out today. But when you come back that day, you'll have a chance to go over that report and recommendation with your attorney. I will have looked at it, and then we'll talk about anything you want to talk about before I sentence. You understand all that? Any questions? Counsel?
No.
All right. Have a good day.
Yeah. I'll be notified of the sentencing date because the sentencing date when he goes down.
Correct. Yeah, because we got your name on the ROA, so you get the notice. Have a good day, gentlemen. Same here.
Set for exam. So is that any on record or no?
Just want to make sure. We ready on Osby? Counsel, your appearance.
That's Hamilton, PA2107 on behalf of Ms. Osby from Daisy. Ms. Osby, who stands by right, could say that.
We're currently scheduled for May 5. That still works?
Yeah.
Okay. All right. So we'll get you a notice and then you can get out of here. All right. Fine. It'll be continued, counsel.
Thank you.
Have a seat in front row, please take order.
I'll just sit in that part of it.
We ready on York? John York?
Yeah.
Go ahead.
Vanessa Hamilton, PA2107. John York, who stands to the right, please stand in for the judge, please.
Alan Wheeler. Thank you. I understand the complainant is present today.
That's great. I think she's on Zoom, Your Honor.
Sharon Hamilton, activate your camera, unmute, please.
Okay, sorry.
Can
Okay,
you activate your camera?
yes, sir. What happened? Okay.
There you go. There you go. All right, Ms. Hamilton, I'm on the record with Mr. York and his attorney. My understanding is you no longer wish to proceed with this case and you will not cooperate with prosecution. Is that correct? And she froze. I love Zoom. And she's gone.
Oh, was she Sharon Hamilton?
Yeah, she just froze.
She must be in on another device. Here she is. Yeah, she's on.
Miss Hamilton,
I'm sorry. Yes, sir.
we
I'm here,
lost
Honor.
you.
Yes,
I'm on
sir.
the record with the People versus John York. It is my understanding that you no longer wish to cooperate with the prosecution of this matter. Is that correct?
Yes, Your Honor.
Okay. And you made this decision freely and voluntarily? You're not being
Yes, Your
pressured
Honor.
to make that decision?
No, Your Honor.
All right. Counsel, you satisfied?
Yes.
You want to make a motion?
Proposal to
Dismiss without prejudice. Thank you, Ms. Hamilton.
Thank you.
All right, sir, did you post any cash bond?
No, sir.
All right, you're free to go.
the dismissal.
I don't have dismissal, but I need a copy of the extra revenue.
Okay.
Yeah.
Malik McAllister? Oh, I'm sorry, you're waiting for Miss Knapp. You're waiting for your attorney?
Here you go, Bill. Copy. Yeah, it's just, Your car's not in the oh, yeah.
Where's that?
Because they're actually true.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before, excuse me, before you signed these, did you go over them with Mr. Crocker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Mr. Liskowski is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. And at this time, also find sufficient evidence to find you guilty. And at this time, find you guilty of evading detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Crawford.
All right.
All right, good luck to you, sir. You can go back to the bailiff. Thank you for being here.
Smith, yes, sir.
All right.
See, Mr. Brian Lane, you've got Heyman Brandon.
Yes, ma'am. And I need to bring you a few things.
Well, he's here, so we'll,
Okay, hold on, Sarah.
you can go ahead and bring him.
What's that, Judge?
You can bring him.
More.
Good morning. Are you Heyman Brandon?
Yes, ma'am.
And this is 21-36605. And it looks like, number one, Mr. Brandon is charged with first-degree felony offense of murder. And Dr. Rapon was requested to do a competency evaluation. I don't know that we've been back since then. We received that report February 12th.
What,
Over here, February 24th.
All right, so I've already made that finding. All right, so what's the announcement?
the announcement, Your Honor, is I'm respectfully requesting one more continuance. What I think, after talking with the state, is that we may eventually, at the next setting, request a bench trial. And we're moving into an insanity. I need an insanity valuation at the time of the offense. So I've got with Dr. Rapon. I'm supposed to meet with him.
Okay.
I just need a little time to get that. The state, after I get that, then we'll move forward and
Okay.
yeah.
Do you think he can get that done in 30 days? Has he already, he's already done the competency. I would think he would be able to.
When he came back from the state hospital, when he was deemed competent, I called Dr. Rapon. Dr. Rapon kind of jumped the gun a little bit and thought I was talking about a competency. I already got a competency from right out and did a competency,
right,
and then billed me. But then, so I was like, it's like, hang on a second. So,
okay.
So he's making an appointment with me. So I anticipate next couple of weeks I'll be to him and he'll maybe.
We'll do 30 days. And if you don't have that back, let us know right before that court date and we can reset it without you guys having to come here if he's in the middle of getting that report ready.
Yes, ma'am.
Okay. All right. You can go back with the bailiff, Mr. Brandon.
Right now, yeah.
See, Mr. Kevin Lane.
Yes, sir.
You've got Ahmad LeBlanc.
He's in custody.
What is this?
How much?
Ms. Malfino, Ahmad LeBlanc.
Sitting here thinking I didn't notice a nice young new probation officer.
All right. Are you Ahmad LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered pleas of true to counts 1, 2, and 3 in a motion to adjudicate probation for possession of a controlled substance, a first degree felony. Hold on, that's not right. On probation for aggravated assault. New allegation is a possession of a controlled substance in Chambers County. And I've received the updated report. It was unagreed. Have you both had an opportunity to review the report?
Defense has none.
Have you? Any additions or corrections to the report?
None from defense.
Only any additional that Ms. Shagwa may have from the probation department, Your Honor.
And is this the one I believe Chambers County rejected the charge.
January 28th, Your Honor.
Okay.
Or refused it.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail and this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while and working a forklift. He does do online classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January 20th, he hired me and then surrendered to the court. Your Honor, his mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products. We are asking that the court, there is another plan to extend him for a year, drop program, and another drug assessment, and we would ask that the court follow that alternative.
Ms. Malfina?
Judge, obviously the underlying offense involving a weapon is concerning. However, it looked like it was an issue amongst individuals who knew one another, probably involving some young women as well. Mr. LeBlanc does not have any criminal history. I hate to see him have felony, but he's also exposed to quite a bit on a revocation of this probation. I would defer to whatever Ms. Shagwell has to add, but I would ask that if he's continued, Judge, that he be extended and possibly have something a little bit more intensive than just the drop program.
Anything to add that's not in that updated report from probation?
No, ma'am.
So, I mean, Mr. LeBlanc, you've done so well. I mean, better than most you've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously, you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I think you've come a long way you're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. You'll be, you'll be required to enroll in and pay for it and successfully complete the Texas Drug Education Offender Program. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes, ma'am.
Okay. So this was an agreement. So you do have some rights to appeal. You can talk to Mr. Lane about that. And I need you guys to sign this, Mr. Lane, please. But you'll be released, and first thing you do is go to probation and make sure you get everything taken care of like you're supposed to, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
So we're gonna need this though, once they all sign it, right? So you just, yeah, if y'all will get this, once you get the signatures, if you'll get it back to Kelly so she can get it filed into the case.
Thank you, Your Honor.
Yes, sir.
Yeah.
See, Judge Walker, you have Paul Nelson.
Yes, ma'am.
Paul Milton.
Have a good day. Doing okay?
Good, how about you?
2 days in a row.
I know. Good morning. Are you Paul Nelson?
Yes, sir.
And will your client waive the formal reading of the indictment in each of the cases?
Yes, Your Honor.
Mr. Nelson, in cause number 23 DCCR 1786, you're charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in cause number 23 DCCR 1787, you are also charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
In each of these cases, I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with your attorney?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone. State, excuse me. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Nelson is not competent?
None, Judge.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 23, DCCR 1786, find you guilty, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 23, DCCR 1787, find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and also concurrently with Montgomery County cases. Is that correct?
Right.
They'll run concurrently with that as well. I'm handing you the trial court certifications. Those show that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Judge Walker. All right, good luck to you, sir. You go back to the bailiff. Yes, sure.
We would ask that the court waive any court costs as he has indigent. The court needs me to inquire about that. I'm happy to, but he's been incarcerated for 2.5 years and he has 0 dinero.
What are the typical court cost on a?
200 and something dollars plus this fee plus that fee. So total in both cases, Your Honor, will be around $550.
What I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly what the process for that, and take into consideration that he's indigent, that you relayed that, and I will let you know exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay, thanks, Ms. French. All right, you can go back with bailiff. Yes, sir.
Have a good day.
You'll make a note for me on that, please. Mhm. Mr. Lewis, you have Daryl Burnworth.
Yes.
Good morning.
Come on, Jim.
How are you?
All right. Oh, that's it.
Good morning. Are you Daryl Burnworth?
Yes, from Burnworth.
Burnworth, and this is cause number 26 DCCR 0038. Mr. Burnworth is charged with theft of property, and that looks like it was titled a first degree felony, but it was amended for the value to be of $30,000 or more, not
Right.
300,000. Is that correct?
That's correct.
What level offense does that make it?
That makes it a third degree.
Okay. Then with everyone's permission, I'm going to make that notation on the indictment. I didn't when I amended it, but that way it won't be confusing when anybody looks at it. So I'm going to take care of that. All right. So third degree felony offense of theft of property. So what is the announcement?
Judge, I have been talking with Mr. Burnworth, and there are some questions that he brought to me in regards to his criminal history that went to the offer that was made by Ms. French at this time. All his history is in Louisiana, so I just need to verify some things for her.
Okay.
So if I can just get a couple of weeks, I think we'll be able to get this one resolved.
Okay. Any issues, Ms. French?
None at all.
All right. We'll reset it to either 2 or 3 weeks, depending on the dockets. All right. You can go back with the bailiff. See, Mr. Lewis, you have William Miller.
Yes.
William Miller.
And this is Mr. Coleman.
Yeah, I think he's the report came back incompetent.
Correct.
Good morning.
Good morning.
Since I hadn't, my only cases got reset, so for like Tom would say.
Nice of you. Good morning. Are you William Miller?
Yes, ma'am.
And this is 26 DCCR 0063. Mr. Miller is charged with the offense of robbery. There was an evaluation for competency that was done by Dr. Grimsley, and received that. Okay, the exam date was March 5th of 2026. The finding in that report is that Mr. Miller is currently not competent to stand trial, and that inpatient competency restoration would be warranted for him to regain competency. Is there any other relevant evidence?
Overstood, Your Honor.
Yeah.
Nothing else,
With regard
nothing
to
else from the
competency.
state.
Nothing from the
Then based on that and based on the report by Dr. Grimsley, I am going to find that Mr. Miller is currently not competent to stand trial. Order that inpatient restoration is warranted for competency restoration, and that he be sent to the appropriate facility for a period of not to exceed 120 days from the day you get to that facility. So Mr. Miller, you'll get sent to a hospital.
Thank you.
And they'll get you taken care of so you can understand everything better, and then we'll get you back to take care of your case. Okay? You can go back with the baby.
All right, thanks, yeah.
Yes. Jamaldrin Willridge.
Maybe we hold on that one, I think.
Okay.
Sure, and maybe when the court has a couple minutes, maybe we'll just speak to you.
We're gonna
about
hold that for a second.
Okay, hold it. Thanks. think once we talk to you, it'll refresh your memory about the budgets.
You fully understand them.
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. And that would likely include mental health treatment so that you can stay on the right path and be able to be successful. Is that your understanding?
Yes, ma'am.
Also, that there would be a dismissal in clause number 25 DCCR 0170 as part of that. Is that correct?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Ms. Bailey, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequence of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And that'll just give me more information about you, your case, and that way also everything will be in place for you to have anything that you need as soon as you start your probation with regard to mental health or anything else, okay?
Yes, ma'am.
And so we'll see you back at sentencing. Okay, good. Mr. Rojas, you have Bethany Batten.
Bethany Banger was born.
Oh, she's, okay,
Transported, yes, ma'am.
okay. We'll reset that. You have, Relacia Mouton.
Those are rejections, Judge.
Relacia Mouton.
Morning.
Good morning.
Good morning again.
Good morning.
Uh, There's 5 cases. I can do. I go both of those,
There's 2 states.
possession of controlled substance state jails and all the rest are second degrees. I can do it without filling that. Good morning, ma'am. Are you Relacia Mouton?
Yes, ma'am, sure.
And Ms. Mouton, in cause number 25 DCCR 0907. Before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there
Did this in January 20th.
the competency reports from October?
You found her competent January 20th.
That's what my file reflects also, Judge.
Okay. Maybe we didn't get her back. I don't know why.
She didn't.
There's a lot of things there with.
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway, found competent based on that report. There hasn't been any other reports that I know other than the Dr. Capon report from back in October. And so any other issues at this point with regard to competency?
No, you're wrong.
All right. So in cause number 25 DCCR 0907, Ms. Mouton, you're charged with the second degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the record. Thank you. And then in cause number 25 DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So this second one, same thing, is a second degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25 DCCR 1468, you're charged with assault on a peace officer. And this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently. And then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm going to make that notation.
Because I just signed paperwork refusing 2 years with both of those.
You did. So obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay, so you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Ms. Mouton, listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we have.
I understand.
So, Mr. Rojas, you're released. And Ms. Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Also, hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change?
No, Judge, I thought that was a very generous offer.
So I do want to make sure you understand that just getting a new lawyer doesn't mean things are going to change. The offer is what it is. And so there's not going to be any change just because there's a new lawyer.
I've seen the tapes and it's not enough on the tape to show that I deserve 8 years.
All right, but that'll be up to
trouble in 20 years.
That'll be up to a jury. That's what juries are for. You can go back with the bailiff.
Makes sense to me.
Mr. Kitchens is on his way over on the wheel.
Perfect. Thank you. She was like, oh, that was funny. Let's see, Mr. Parker. Ms. Holmes and Mr. Parker are both in the back. That's fine. If they're working on something. Dang. That Ms. Holmes. And then we'll
You fine.
Okay.
September 26th.
The last one. All right, are you Jameldrin Wilridge? And so before we go forward, Mr. Lewis and Ms. Malfino approached about possible solutions to the issues that we have here with Mr. Wilridge is on probation. In 3 cases, there was a new offense that occurred while he was on probation, but before he went to ISF as a part of that probation. And what I want to know before I consider any type of continuation of probation is couple, I guess, number one, how do you have any idea how he did, Mr. Kitchen? I guess, and before you go forward, would you raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
Any issues with regard to behavior at ISF that you were aware of?
None that I'm aware of.
Okay. When did he get back from ISF?
I'm not sure exactly. I did not receive Mr. Woolridge under my supervision until September 26th of last year.
Okay. And how has he done from then until he was incarcerated on this?
That went in the contact, and he was very cordial with me. We've had cordial bit surprised by this and the other stuff that's been going on with it.
Okay. Any positive drug screens, any issues at all since you had them in September? Okay.
May I just ask him one question for the court?
Of course, please.
Mr. Kitchens, you brought to my attention, and I think the clerk has also sent it to Mr. Lewis and myself. His behavior in jail is less than to be desired, correct?
Yes, that's correct.
And would you characterize that as his association with those individuals who the court is very well aware are in jail, that it is that is a different side of him than you saw while he was out on probation under the guidance and eye of the court and his family.
That's correct.
With the understanding, I'm sorry, Judge, if I may, that obviously Mr. Wilders is facing quite a bit of time from this court on a revocation. And would it be your intention, along with the court and myself, to make it clear to him that if he is given this opportunity, that if he comes back before this court, that he's not looking at maybe what he would be looking at today, but probably 3 times in advance of that amount of time?
Yes.
And do you think he is capable of and understands the seriousness of what it is he's facing?
I believe he does, yes.
From your interaction with him.
Okay, well, Mr. Woolridge, this is tough for me. Because you've been given a couple of opportunities and this would be another opportunity. And I don't know, I don't want you back in here. I don't want you to violate. I want you to be successful. You've been on a decent path. But what you did and thought you got away with, things catch up with you. Right? And so that one's a 2 to 20 case. I could revoke you on your ag robbery and send you to prison for the rest of your life today. The rest of your life. And based on the history and what's been going on, some big fat number is probably what you deserve. And so I don't know how to be any more clear than if I give you this opportunity with what your attorney is working out with the district attorney, that Mr. Kitchen sounds like he's willing to work with you. And if I go along with this and leave you on probation and put you on a new probation, if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand? Mm-hmm. You're going to be on 0 tolerance. That means no mistakes on probation. You've been on it long enough now to know how to be successful or not on probation. And if you just live your life right and do what you're supposed to, that shouldn't be a problem. It's only hard if you're doing the wrong things. Does that make sense? Yes. All right, y'all can do the paperwork.
Thank you, Judge.
Thank you.
Mr. Parker, you have Lloyd Calhoun.
Yeah.
Judge Parker didn't have his thing yesterday. I said, you better do that because she won't let you plead. What is that? I think they just haven't said, you have to have the attachment.
All kinds of new stuff's happened since he was up here, all the words that I could say. Good morning, are you Lloyd Calhoun? And Mr. Parker, will your client waive the formal reading of the indictment?
Hey, will, Judge.
And we're just going in the possession case, is that correct?
That's correct, Judge, but on the, with the prior enhancement counts to make this a 3rd degree, and just so to be candid with the court, in 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense. What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay. All right, Mr. Calhoun, in cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a 3rd-degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a 3rd-degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by felon, July 8th of 2019. And are all 3 of those prior convictions true?
Mm-hmm.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you? Do you fully understand those documents?
Some of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow this agreement, you can't change your mind later, right? And it looks like the agreement's for 5 years in prison with a dismissal and cause number 25 DCCR 1267, which is that tampering case.
Yes.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Back time?
Yes.
No.
Just the time that we've had a hold on you here. So I don't know if you're serving time anywhere else or were anywhere else. Okay. So you'll get that credit. I'm going to, is it not printing?
Okay.
I'm going to hand you in just a minute a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You already know this because I know you have a history with a charge of this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And then I will sign a dismissal as soon as it comes through in clause number 25, DCCR 1267.
So now,
You put in the holes.
Well,
I think I probably printed it twice at least.
and this is, what I printed stuff for Pam a while ago,
Oh.
and what I gave her wasn't all of it. Apparently ran out of paper when I didn't know.
I printed some stuff also from that other case.
Okay.
I printed one for me, several things for myself.
Well, I think it's something.
Okay, all right. Here you go. You can go back with the bailiff.
Yeah.
I mean, ask them every time. You understand, I tell you everything you're gonna say. Give me questions. You understand everything I've gone over to you. Okay.
I know.
They always got, they gotta say something. I guess he understood, he didn't understood.
That's true.
Pam.
Oh, she probably wants to file that.
Well, tell that copy I gave her.
Mr. Parker, you've got Patrick Trahan, 2 cases.
Patrick Trahan.
Right here.
There's actually 3 cases, one of them being dismissed.
Thank you.
Judge, that was based on the fact that you just came back confident with trying to dispose of that situation, that window.
So, which one's being dismissed?
The 9-6, whatever, then 1-6.
1916. Okay. Good morning. Are you Patrick Trahan?
Yeah.
And Mr. Trahan, I'm going to take judicial notice of the court's file in all of his cases. Mr. Trahan was evaluated for competency by Dr. Gapon. And we received that report dated March 2nd of 2026. The finding in that report is that Mr. Traxman is currently competent to stand trial. Any other evidence with regard to competency
No, Your Honor.
from the state? No. Then at this time, I am going to find that Mr. Trahan is competent to stand trial. Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
No, Your Honor.
And are we going on count one only? On the assault on a peace officer?
Yes, Your Honor. We may need to go on both on the stage.
Okay, hold on a second. Sorry. All right, Mr. Trahan, in cause number 25, DCCR 1917, the state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer, and that's from November 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then takes a minute for me to get it. And clause number 26, DCCR 0592, you're charged with the state jail felony offense of possession of a controlled substance from March 17th of 2025. And how do you plead to that charge?
Yeah.
Again, are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? Also in that indictment, it alleges that you were previously convicted of the state jail felony offense of theft of copper, bronze, or aluminum, August 11th of 2014. And then after that was final, you were convicted of burglary of a building, a state jail felony, May 15th of 2015. And are those two prior convictions true?
Yes.
In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I do.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Right.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Yes.
It's admitted in each case. Get caught up here. Right, so I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you entered your pleas of true also in the second case freely and voluntarily. Find again that you're mentally competent, that you understand the nature and the consequences of your pleas. In cause number 25, DCCR 1917, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0592, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance find those 2 prior convictions true, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Those 2 cases will run concurrently, which means together at the same time. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a trial court admonishment, or the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, and I will sign that dismissal now in cause number 25 DCCR 1916. All right, you can go back with the bailiff. All right, let's see, Eric Tran.
More flash. I don't have anything. I just took comments without taking fire. I played with everybody but you and Donovan. And then one of the comments got reset, one was in comment.
So you guys say P, but I don't know, you gave me credit for time served on the reckless.
Yeah.
Are you gonna dismiss it, or is he gonna plead it?
Oh.
It's crazy.
These are policies.
Yeah, right. Okay.
I'll get them to do that. Is it set today? Do you know?
I don't know. They usually said it today, but
I'm asking. Right?
Yeah.
They're asking where it is, and I'll go to that.
is it here? We got 2.
It's in
Yeah, it's here.
And y'all see my God, you want to put your misdemeanor things at 2 to 3. You didn't. I mean.
Good morning, sir. Are you Eric Tran?
If you know.
And Mr. Parker, will your client waive the formal reading of the motion?
Here we are.
Mr. Tran, in cause number 22-40541, I have a motion to revoke your community supervision. It shows that you were placed on probation January 17th of 2023 for evading arrest or detention with the use of a vehicle, a 3rd-degree felony. And that was a 10-year term in prison that was probated for 5 years. Is that correct?
Mm-hmm.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of reckless driving November 28th of 2025 in Jefferson County, Texas. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample March 10th of 2025 that tested positive for the byproducts of cocaine. And is that true or not true?
True.
And then count 3 alleges that you have failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation, but order that you enter and successfully complete the safety program. And then you would be back on probation and required to follow all of the rules and conditions. Is that your understanding?
And Judge, that was the recommendation when I spoke with this officer, Judge.
Okay, thank you, Ms. Malfino. And it looks like also you would enter a plea on that reckless driving for the time that you've already
I
served.
think you can get your credits. We're probably gonna dismiss it, Judge. I mean,
He's got so much
Oh,
credit
okay.
that it'd probably technically easier.
Yes, we're gonna resolve that today.
Let him go.
Okay, so then what I'm going to do, Mr. Tran, it sounds like everybody's wants to get you back on track, and that's what Safety is for, so that you can have the tools necessary to be able to stay clean, and do everything you're supposed to on probation. And so I'm going to follow the recommendation from probation and the district attorney's office. Find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke the probation, but I'm not going to. I am going to continue you on probation. I'm going to order that as a condition of that probation, you enter and successfully complete the safety program, and then follow all of the other rules and conditions of probation. If you do all of that, we should never see each other here again, and you'll be able to finish that probation or your time while you're out on probation. But you need to keep in mind, if you mess up again, you're going to be back here in court, and we're not going to be talking about the same type of thing. You'll end up going to prison. You've already agreed to a 10-year sentence. Okay. Good luck to you, sir. You can go back with the bailiff.
Do you want to,
See, Ms. Holmes, you have Edwinia Johnson.
Yes, Your Honor.
it's a, that's the wrong structure. I think it's last one.
Sorry.
I'll check this. Oh, well, thanks. I didn't do it.
They're for bonds, right? We're not, or she entered pleas on them, or just here for bond? Thank you.
And I didn't, there was a bond set on it. Has she been a lot of them?
They used to have 2 robberies, two into, 3 into, or
I've got one robbery.
Yes, one. It's, but that's somebody else. Yeah, that's not.
Well, we'll get turned off for that because of the name.
And so the request for bond are on the 3 MTRPs, correct?
Yes, Your Honor.
Good morning. Are you Edwinia Johnson? Yes, ma'am. And Ms. Johnson's here, and cause numbers 24 DCCR 2151, 2152, 2153, and then there is also cause number 25 DCCR 1826. And the first 3 cases are all probation cases that Ms. Johnson is currently on, and there's been a motion to revoke filed in each of those. The underlying offenses are forgery, abandoning or endangering a child in the other 2, and then that new offense is for robbery. Ms. Holmes filed a motion asking for me to set bonds in those 3 underlying motion to revoke cases. She's on deferred, but I set it for a hearing based on that underlying offense. I want to know really what's going on before I figure out an amount or if I'm going to set bond. So Ms. Holmes, I'll let you go first. You're going to call your client for the purposes of.
Yes, Your Honor.
Ms. Johnson, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you. You may proceed.
Okay, you, Edwinia Johnson? Yes. Okay, Ms. Johnson, how long have you been, in custody at the Jefferson County Jail?
2 months and 8 days.
Okay, and, you're in there because you understand that there were motions to revoke probation due to, allegations that you violated probation, correct?
Yes, ma'am.
Now, the, alleged offense of robbery, is one of the underlying allegations. You're understanding of that, correct?
Yes, ma'am.
And which the offense date was not very long after you were placed on probation.
Yes, ma'am.
Okay, we've discussed that. While you have been in custody, we've talked about you trying to wanting to get back on track with probation, and while all of this is pending, correct?
Yes, ma'am.
Now, if the judge was to set a bond, where would you be residing? You don't have to give the exact address, but would it be in Beaumont?
It was in Beaumont.
Okay.
Either way.
Okay, and, you have, family who have obviously reached out to me who would be, supportive of you, to make sure that, you come to any and all court proceedings, and that you do whatever is necessary, and that you understand that if you, are given a bond, that there may be certain restrictive measures, such as GPS monitoring, things of that sort, placed upon.
Yes, ma'am.
Okay, and are you asking the court to set a reasonable bonds in your cases so that you can hopefully be released and try to get back on track with probation? It doesn't seem that you got very far with starting probation because you hadn't been on it very long. Is that
Yes, ma'am.
correct? Okay, and so you're asking for bonds to be set so that you can try to get back on track with that.
Yes, ma'am.
I'll pass the witness, Your Honor.
No questions.
All right, any other witnesses?
No, Your Honor.
Mr. Smith?
Judge, because they're deferreds, I believe that you have to set a bond. We would request those be fairly significant bonds. The underlying offense, even though it's not with strangers, it's people that she was living with. There was an argument, it turned violent. This defendant did not live there, but she was there. She gets in on it, holds her down while they take this other person's phone, ripped it right out of her hands. So this is 1 week after she went on probation in these 3 cases.
Last week.
Not yet.
And obviously she doesn't understand the significance of what is being held over her head. I don't know that I would offer to keep her on probation based on that without some kind of significant cognitive treatment so that she would understand how to make better decisions. But we would request those bonds, like I said, to be significant.
So probation started in all 3 of these cases, October 6th of 2025. And so probation's here. And ma'am, would you raise your right hand, please? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And so were you able to have any meetings with the defendant, Ms. Johnson?
Yes, ma'am. I met with her in October when she first got placed on probation, and then again in November. But when the offense occurred, she then reported to me when I met with her in November. And that kind of was alarming to me. And then also in November, she told me that she was in Houston. No, I'm sorry, I think that was December. She went to Houston without letting me know first. So that was also another concern. And so there may be some compliance issues with that.
Okay.
And in the pre-sentence report, I think he is sincere about that. He doesn't have a prior record as far as driving. He's stayed away from alcohol and cannabis this whole time that he's been out on bond. And that would suggest to me that he doesn't have some kind of serious substance abuse problem. But if you require him to do counseling, he'll certainly be compliant with that. I think he'll be a model probationer. And I'd ask you to consider probation. Judge, I would just finally say, I really think that Jonathan, he hasn't had the easiest way to go. He was in foster care at 6 weeks. He was adopted when he was 2.5 years old. All along the way, I think he's been trying to build what we would call a normal childhood, a normal life. He's now working. He's on the right track. And I think he's done an excellent job. He has goals in mind, and I think he's going to continue on that course.
Thank you. Mr. McGinnis, is there anything you'd like to say?
I just wanted to start off by saying I apologize to the officers and
everybody that was on the road, and I put their lives at risk. And if you will give me a chance to stay on probation, I'll continue to follow all the court orders, stay clean, and stay at my job.
And your job is the tire discounters on Colerain Avenue?
Yeah.
Okay.
Mr. McGinnis, tell me what your thoughts are, the state of Ohio, the prosecuting attorney asking that I sentence you to 24 months in prison. What's your reaction to that?
I mean, I understand it. Like 10 years ago, the officer got killed, and it's not good.
Does that scare you at all?
Yes, Your Honor.
All right. Can you explain to me why you ran?
I have no excuse. I panicked and made a bad decision.
Well, I mean, again, in that moment, what was your thought process as to why you thought that would be a better idea? Did you think that the police were not allowed to pursue you?
I know that they're allowed to.
I mean, did you think you were really going to get away? I mean, I'm trying to figure out why. I mean, people have all kinds of reasons for running. I'm not really sure in that moment. You went from a speeding ticket to a felony with up to 60 months in prison. That's 5 years of your life in prison that I could send you. I'm just trying to figure out in that moment what your thought process was.
Oh, if I would have got another ticket, then I would have lost my job. But now I understand that losing my job is better than putting people's lives at risk.
All right. Anything else you want me to know?
No, Your Honor.
All right. Of course, consider the statements made here today, the pre-sentence investigation. I have reviewed the letters submitted on behalf of the defendant. I've considered the purposes and principles of sentencing, the relevant Is there something you'd like, sir?
Your Honor, I'm sorry. I neglected to mention this. This is his father.
Okay.
He said he wanted to say something.
Oh, sure, absolutely. Come up to at that table there, sir. There's a microphone right there. It'll pick up your voice just from right there.
Okay, thank you, Your Honor.
Identify yourself for the court reporter, please.
Please?
Just state your name.
Edward McGinnis.
All right, what can I do for you?
I just wanted to make a statement. What my son did was absolutely wrong, and I thought I instilled that in him. Irregardless of what I thought I did, he did what he did. He is guilty of that. But to me, when I'm not a lawyer, I'm not whatever, but I look at things, is he going to be a better person, a better part of society by going to jail or coming out and being with his family and us moving forward and progressing him so he is a better person as a family member, as a person in society, working a job and not being in the system to where I feel that things could change him in a different direction. And that's all I have to say.
Okay. And I don't necessarily disagree with you, anything that you've just said, but I would add that from where I sit, and again, I'm not perfect. I make mistakes. We all do.
Yes, sir.
My children, when they were growing up, made goofy decisions. But I've always tried to teach them when you make a bad decision, there's bad consequences to that decision.
Oh, absolutely.
So as we stand here today, although I certainly wish the best for him, there are going to be consequences today. Fair?
I understand that, sir.
Okay. Anything else you'd like me to know?
No, sir.
All right. Thank you, sir. Anything else, Mr. Mason?
No, Your Honor. Thank you.
All right. All right. The court, as I said, has considered the statements made here today, the pre-sentence investigation, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. Mr. McGinnis, the court is going to find that you are amenable to community control. So I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. I'm ordering you to refrain from use of any drugs, alcohol, or marijuana. You're not old enough to drink alcohol nor smoke marijuana. So that's the end of that, correct?
Yes, sir.
All right. There's been no recommendation for any type of treatment. The court is going to order you to serve 60 days in the Warren County Jail. I'm going to do something with you that I have never done before. Well, first, I'm going to let you schedule that with your probation officer. But the thing that, and that's not unusual because I let people do that. I'm not going to take you into custody today, but I'm going to allow you. Are you supervising, Lily?
Yes, sir.
Okay.
This is your probation officer sitting right here. She's going to want to talk to you after course. But one of the things I want to do for you, because you're not going to have a license after today for the next 5 years. I'm suspending your license for 5 years, effective today. Can't drive anymore, okay? But I'm going to have you serve 60 additional days in the Warren County Jail. He can pick those those days, and they do not have to be served consecutively. What that means is you can work during the week and spend your weekends in jail, but you're going to serve an additional 60 days. You have served 6 days, you're going to serve 60 more, okay? And I generally make people serve those straight through, but I'm going to get, since you're not going to be able to drive and you're working in Colerain Township, you're not going to be able to drive to and from work, so let's do it on weekends, okay? Or however you want to arrange that with your probation officer. I am going to assess a fine against you of $2,500 and the costs of prosecution. If you don't pay those costs, I can order you to do community service of up to 40 hours per month until you're paid in full or an appropriate arrangement is made to pay those costs. Now, you're also subject to a mandatory period of post-release control. Now, what that means is that if you are ever sent to prison on this charge, and you're not being sent to prison today, but if you screw up again and the court ends up sending you to prison, when you are released, the Adult Parole Authority will supervise you for up to 3 years, but not less than 1 year. If you violate those rules of supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's sentence. If your violation is that you go out and commit another felony, that trial court could order you to serve an additional prison sentence of 1 year or whatever time you have left on post-release control, whichever of those is longer, and that time would run consecutive to any additional prison time that you get sentenced to, okay?
Yes, sir.
Now, you have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can be provided to you at no cost. Do you have questions for me?
No, sir.
Dad, Mr. McGinnis, do you have questions for me, sir?
I'm with the fine, basically set up a payment for that. Okay,
It's not my highest priority, but
yeah, but I just want to make sure
it does not have to be
We'll
paid.
make out the arrangements for him to be here when he needs to be.
Yes, sir. Mr. Mason, is there anything else?
No, Your Honor, thank
Ms.
you.
Tranter, is there anything else?
No, sir.
All right, Mr. McGinnis, Ms. Williford's going to want to talk to you for a little bit after court. Okay, so head back down to court services, and then she's going to go over with you in more detail the rules of your supervision, okay?
All right, thank you.
Best of luck to you.
Thank you.
Thank you, Your Honor.
Thank you, sir. This is case number 25CR42736, the State of Ohio versus Jennifer Wilson. Ms. Wilson is before the court with her counsel, Mr. Adams. Ms. Tranter, on behalf of the State of Ohio. Ms. Tranter.
Your Honor, I believe that Ms. Wilson is prepared to enter a plea today. Is that correct, Mr. Adams?
It is.
She's going to be pleading as charged. Count 1, failure to comply with the order of signal of a police officer is a felony of 3rd degree. Count 2, operating motor vehicle under the influence is a misdemeanor of the first degree.
All right. And Mr. Adams, is that accurate?
It is.
All right, Ms. Wilson, they're telling me you're going to change your plea to 2 counts from the indictment. Before I get to your change of plea, I'm required to go over some things with you, okay?
Yes, sir.
How old are you?
I'm 53.
How far did you go in school?
I went to high school and I graduated and then I went to nursing school.
All right, are you able to read and write okay?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you in this case?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Adams?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with Mr. Adams before you signed it?
Yes, sir.
And you feel like you understand what it says?
Yes, sir.
All right. This document says you're entering a plea of guilty to 1 count of failure to comply with an order or signal of a police officer. That is a felony of the 3rd degree and carries a maximum penalty of 60 months in prison and a maximum fine of $10,000. The prison term is not mandatory. Although I think the state is going to be asking that I send you to prison, just for your fair warning. The second count is that also carries with it a mandatory operator's license suspension of 3 years to life. The second count is one of operating a vehicle under the influence, a misdemeanor of the 1st degree. That carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. That also carries with it mandatory penalties of 3 days in the Warren County Jail, a mandatory fine of $565, and a mandatory operator's license suspension of 1 to 3 years. Do you understand the maximum and mandatory penalties involved?
Yes, sir.
Now, on the felony charge, you're also subject to a mandatory period of post-release control. What that means is that if you are sent to prison on the felony, when you are released, the adult parole authority will supervise you for up to 3 years, but not less than 1 year. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But as I've said, it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation. While on community control, you will also have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the prosecutor has against you. With the help of Mr. Adams, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You also have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's called your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
You understand that when you enter a plea of guilty, you will be waiving all these rights. We are not going to have a trial.
Yes, sir.
This is how you want to proceed today.
Yes.
All right.
Your Honor, in addition to the facts alleged in the indictment, this event occurred on May the 29th, 2025, Warren County, State of Ohio. Defendant was operating her vehicle at a high rate of speed. Officers attempted to conduct a traffic stop. Defendant accelerated, topping off speeds at 103 miles per hour. It eventually ended up going out the right side of the roadway, overcorrecting, rolled her car multiple times, struck a concrete divider, and the car ultimately caught on fire. She was transported to the hospital. She exhibited both max clues on the HGN as well as the VGN. She admitted that she was on antidepressants and antipsychotic drugs as well as to drinking at the time of her operation of the vehicle.
Mr. Adams, anything on those facts?
No, sir.
All right. Ms. Wilson, did you hear the statement that she read?
Yes, sir.
Do you acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, those rights we went over.
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I am not going to get into the matter of sentencing today, Ms. Wilson. I'm going to order a pre-sentence investigation, and we'll come back in a few weeks and do sentencing at that time. Mr. Adams, you wish to be heard on the issue of bond?
Yes, sir, Judge. There was a period of time where Ms. Wilson's sanity and competency and restoration of the competency was in place. We've seen reports, we've stipulated to the same. I would ask that she be released. And she previously performed well on bond, Judge, when there were the SCRAM or alcohol monitor was in place. Her father and other family are here. I know that she has a place to stay. It was where she was previously staying before. I do think it's probably in her best interest as well as to ensure compliance with pretrial conditions that the monitor be in place. To be candid with the court, I think that gives her the ability to come out of jail and make sure that she is insured to follow through in the short term. Obviously, that's not a lifetime. We can't put ankle monitors on people for life. So hopefully the skill set that she's able to gain through whatever conditions this court deems appropriate will aid her in that. But I would ask for her to be released. She has a significant amount of time in custody at this point, Judge. It's probably 7 or 8 months. At this point, I don't have the exact number, but she's been in for quite a long time.
Are you ordered on any medication right now?
In my court order?
Not court ordered. Let me rephrase that. Have you been prescribed any mental health medication?
Yes.
Are you getting that medication over at the jail?
Not all of it, no.
Tell me what happened back in October when you were out on bond and then you were driving again, apparently impaired, and before you ended up at Beckett Springs. What happened there? You were on an alcohol monitor. They were getting notifications that you were using alcohol. You then again got behind the wheel of a car and drove somewhere while on monitor. Explain to me what happened in that. Were you cited for that or anything? Is there any charges that came out of that?
I don't think so.
Not that I'm aware of, Judge.
So, okay, so now tell me what happened there, because I mean, I have a concern about the safety of the public. If I'm gonna let you out of jail and you're gonna drink alcohol, abuse your medications, and then get behind the wheel of a car, that concerns me. Is her license suspended right now? Is she under an ALS?
I believe she is under an ALS.
Was there a test or a refusal?
There was no test.
Refusal? So she's under an ALS. Okay. You're not allowed to drive right now. You understand that?
Yes, sir. Yes, sir.
So can you explain to me what happened back in October when I revoked your bond? If you can't, then that's fine. But if you remember and try to explain to me so you
Oh, I
can,
needed help.
I'm sorry?
I needed help.
You say your father's here in the courtroom?
Yes. Stand up. Can you stand up?
Sir, do you have the capacity to supervise her to make sure that she doesn't get behind the wheel of a car?
Sir.
All right, does the state have a position?
Yes, Judge, we would ask she remain pending sentence. I think it's a terrible idea to let her out. I'm reviewing my notes from back in October, and I believe, in fact, I know this is the case that Officer Conroy was down here and spoke to the court about numerous alcohol events. And I think she said there were so many, she in fact blew up her TAB monitor. I think she's a very big risk. I think we need to get her assessed and come up with a plan for her before we even think about releasing her back into the community, because I think she's just too much of a danger.
Judge, if I may, in
Sure.
response to that, and I appreciate counsel's thoughts. I understand where she's coming from. I think there were competency issues at that point in time that were still being resolved and or unresolved. Those have, according to the reports that we've all stipulated to, been resolved at this point in time. She has been in custody for enough time that, you know, she's had alcohol out of her system. I will certainly, you featured, and I think fairly so, and I've already previously told Ms. Wilson that the state's going to be asking for prison. I clearly will be asking for her to be given credit for the amount of time that she's done and do the treatment and the assessments and things like that Ms. Trainer spoke of, because I think those are important. What I would ask the court is, you know, if we're going to be able to find out whether Ms. Wilson was under competency and or needing help, as she described it, conditions, well, she's received that at Beckett. I think we need to see whether or not she can do this or not. This will be the kind of a little mini probation period. And if she does well, then obviously I'll be arguing, hey, Judge, she's done well. If she gets out and she doesn't do well, then, you know, she knows where her next address is going to be.
Sir, you had something. Sir, would you tell me your name, please?
My name's Gerald Thornton. I'm a friend of the family's.
Okay.
When she was on both monitors, she did extremely well. I don't know what the prosecutor had to say about it, but she was extremely well and went to all the court dates, and we made sure she was there. It is when she had the other monitor off is when things went awry.
Okay. All right. All right. I don't, thank you, sir. I don't have a bond report, so I don't know. Does she have a prior record?
One question.
Judge, she's got some misdemeanors. She has an OVI from 09, another OVI from 05. She's got a child endangering with an open container in the vehicle from 05. Most recently is a disorderly conduct out of Kettering, reduced from an M1 possession of drugs. That was in 23.
Okay. All right. Thank you. Court is going to grant defense request, and I'm going to release Ms. Wilson on an OR bond. Should be placed both on electronically monitored house arrest and a TAD monitor. I'm going to go along with Mr. Adams' recommendation. And Ms. Wilson, I'm cautioning you. I understand that you have mental health issues, but you know that's not an excuse for you to misbehave. Follow your doctor's orders. Take the medication as prescribed. No alcohol. You can't mix them. Do you understand?
Yes, sir.
If you violate my orders on bond right now, I can guarantee you that when you come back for sentencing, I'm going to send you to prison. Are we clear on that?
Yes, sir.
So you, Mr. Adams is right. You have an opportunity right now to show me over the next several weeks that you will comply with the court's orders, that you won't break the law, that you won't abuse your medication or alcohol, and that you can follow my orders and be a successful candidate for community control or probation. Do you understand that?
Yes, sir.
But if you go out, if you go back to your dad's house and you start drinking again and you're getting behind the wheel of a car, which you're not allowed to do, we're going to have a problem because I will send you to prison for 2 years. And I don't think that's what you want. And that's certainly not what I want to do. I want you to be successful. Okay?
Yes.
Okay.
Judge, so we're clear, so she's clear. It is an order of this court that she not consume any alcohol.
Absolutely not. You are not permitted to drink any alcohol whatsoever. Do you understand? Not a glass of wine at dinner, not a sniff. Don't go near it. You have an alcohol problem. I'm guessing we're going to get an assessment, but I'm going to guess with 3 OVIs, you got an alcohol problem. You probably could have gotten a 4th in this October incident, but we're not going to worry about that now. I want you to get some help. Okay.
So before, when he said don't mix your medications and your alcohol,
Yeah.
that doesn't mean you don't take your medications
Yeah.
and therefore you can drink.
Right. You're not allowed. You're no alcohol at all. That's a condition of your bond. Okay.
Thank
No
you.
alcohol.
Thank you.
All right. So I'm going to have both. They'll have both monitors put on you, and you'll be released. Okay. Anything else we need to do?
No, sir.
All right. Thank you all.
Thank you.
Thank you.
Call me.